I'm going to try maybe on break. I was hoping the morning recording would be uploaded in time for me to, but it hasn't happened yet. Zoom's got to process and do its thing, and then YouTube has to upload, So if I can't get this YouTube channel link to you guys before we're done with class today, then I might just email it to you guys tomorrow. So if you want to do something with it, you have it. So I might just do that later tonight, but we'll just see. It still might happen during class. Just a quick announcement just for you guys to see. While we were at break, I created our Campbell folder in Learn Test Pass. So if you guys are looking in here, way down at the bottom is Campbell. So all of our PowerPoints, everything that we're going to look at together is in here. If you guys want to go back and review, you have it available. And then I also have that letter from the Real Estate Commission that I put in the chat. Some of you said you couldn't access, so I just went ahead and put it in Learn Test Pass right now. Again, it's just kind of it's really interesting. You know, a lot of it depends on the court's interpretation that day. You know, so far there's been no case where the broker's email has bound the parties, but just know that you never know what could happen, right? It could become a thing. Particularly what I like about this article is watch what you say and how you say it. So it kind of gives us some tips, making sure that when we are communicating with the other agent, we're not accidentally locking our clients in. So that's under our Campbell folder and Learn Test Pass. Any questions or comments about anything we've talked about chapter 11 so far? Hope it just kind of served as a good basic review. Half of you went through pre-licensing in North Carolina. The other half of you went through pre-licensing in another state. So we're all here together now, and it's important that we're all on the same page. We have an understanding of North Carolina and contracts. So no matter where you come from, that's why we're here. As I mentioned before lunch, we're going to kind of skip around a bit. So hold on to chapter 11 for a bit. We're going to fast forward and we're going to go to chapter 14. And in your manual, chapter 14 starts on page 459. Again, the reason I am skipping around is because I want to do the math with you guys Wednesday, as opposed to Monday afternoon right before your test on Wednesday. So I want to go ahead and knock this out. We will not get to the math today. We got quite a few things to talk about before we can actually do the math. But Wednesday, when we come together, on the 14th, will definitely be our big math day together. And I can't make you guys do anything, but I will have homework recommendations. So the suggestion is if you do the homework recommendations, then you're getting yourself prepared for that exam a week from Wednesday. So chapter 14, a couple different sections. The first section, again, we're on page 459. And in this first section, we're going to talk about some pre-closing procedures. Remember, 14 is our closing chapter. So before we get to closing, though, we got to do some pre-closing stuff. And that does include talking more about the buyer's due diligence process and what the buyer should be encouraged to do during their due diligence process. And then we're going to talk about some closing methods. Patricia, I think it was you that mentioned this morning that you guys in Texas use a escrow agent. In North Carolina, we use a settlement agent. We use a closing attorney. So this is definitely one thing that kind of separates North Carolina from other states. So we're going to talk about what those methods are, and particularly what we do here in North Carolina. So chapter 14, again, we're going to go to closing. And I like the visual when we talk about closing of the working gears. I actually use this image, not exact image, but this idea of the working gears when I'm working with buyers and sellers. And I tell them to think of the contract to closing process. We're a whole bunch of working gears, aren't we? So if you put, for example, the listing agent and the seller on a gear, and the buyer's agent and a buyer on the gear, and the lender gets a gear, and the surveyor gets a gear, and the appraiser gets a gear, and the home inspector, who else is involved? Pest inspector, you guys with me? Everybody that has a role in that contract to closing position gets a gear. What happens if one of these gears stops? The whole thing stops, doesn't it? The whole thing stops. Part of our job, I've learned as real estate agents, is keeping these gears going, making sure your buyer's communicating with the lender, making sure the survey is ordered and the home inspection and the pest, right? Keeping these gears moving so we can all work towards that common goal of closing. We are all in this together. We have one common goal, common objective, and that's to get it to closing. Fingers crossed, we can do that. When we look at our contract next week, we're going to differentiate between settlement and closing. Agents talk all the time about going to closing. I'm going to take my buyers and I are going to closing. I'm going to closing today. Woo, closing day. Y'all want to know the truth? I have a confession to make. In my 21 years, I have never, ever been to closing. What we attend with our clients is actually settlement. Now, we don't call it settlement in the real world. If you tell your buyer you're going to settlement today, they're going to look at you like you're crazy because they don't know what that means. What do they know? They know it is closing. But for our purposes, we need to understand that there is a difference. Settlement is when the attorney is gathering all signatures of buyer and sellers and funds. Buyers most often have to bring money to closing. Sometimes sellers have to bring money to closing too, don't they? If the seller's underwater, if they owe more than the property's worth, then they may have to bring closing to money to settlement. So the attorney's gathering the signatures and the monies from buyer and seller. And then we all get up and leave. We all leave the attorney's office. And it's once we leave that the attorney proceeds with closing. Closing's putting the finishing touches on everything. Getting the wired funds from the lender, for example, requesting title insurance. We'll talk more about that. The very last act of closing, the very last thing to happen is when the attorney records the buyer's brand new deed. Then and only then is it a done deal. Now, usually we all work really hard for settlement and closing to happen on the same day. In a perfect world, settlement and closing, we all do our thing at the attorney records, the buyer gets keys, it all happens today. Most attorneys aren't scheduling settlement past like 3 o'clock in the afternoon, maybe 3:30, so that they can have time to still do what they need to do before the Register of Deeds shuts at 5:00. They're not going to stay open until 5:01 because your attorney needs to record. So they're done and locked up tight at 5 o'clock on the dot. Could something happen between settlement and closing? Sure. What if you lose internet, as we were just saying? What if you lose power? You can't e-record if you don't have power. So most of the time, everybody works really hard to make sure that settlement and closing happen on the same day. But just keep in mind and just prepare your buyers and sellers that it's not a done deal until that new deed is recorded. And if for some reason it doesn't happen today, then it won't be a done deal until tomorrow or the next business day. So let's back up just a bit. We'll revisit this again, but let's back up just a bit and talk about some pre-closing procedures. First off, buyers have things that they pay for and the sellers have things that they pay for. Now, this is part of what we're going to discuss when we look at our closing disclosure at the end of this unit. But as far as who's responsible for paying what, well, in some cases, our contract tells us this is the buyer's responsibility, this is the seller's responsibility. In some cases, we rely on customary practice, just because that's what we do in these parts. One thing I have learned about being on Zoom for post-licensing, I love that Zoom has opened us up. We get agents from all over the state. Even you guys, the 5 of us, are not in one central location. So you may have a different customary practice in your neck of the woods than what we have here, and vice versa. And one thing about Zoom that's really opened my eyes is seeing how things are different. I always thought, well, this is how it's done because this is how we do it in Triad. And it didn't take me long to realize that even Raleigh's different, Charlotte's different, right? Wilmington. So a lot of it just may depend on how they do things in your area. The buyer hires the attorney, the person acting as the closing attorney. The buyer hires them. The buyer gets to select who they're going to choose to handle their closing. Now, most buyers don't know closing attorneys. Maybe they do, but it's been my experience that most don't. So they're looking at me, aren't they? Julie, who should I use to conduct my closing? One thing we need to be very careful about. I'm never going to look at a buyer and say, this is the attorney that you are going to use. Instead, I'm going to look at my buyer and I'm going to say, here's the name and number, name and information of a couple of attorneys I have used in the past. I'm going to give them recommendations. If you've never used an attorney before, then your firm probably has a preferred vendor list. So you can say, here's a couple attorneys that my firm has used in the past until you start forming those relationships. We need to give them choices though, you guys. Give them 2 or 3. Even if they don't research it, they're still the ones deciding what attorney to use. I cannot tell them what attorney to use. For that matter, I cannot tell them what lender to use, home inspector to use, pest inspector. This is all them. So I need to provide them choices. And because the buyer hires the attorney, that means that the attorney represents the buyer in this closing transaction. If the buyer comes with a lender, then the attorney is going to represent the lender in their interest as well. Seller, I would say typically in this part of the country, or in this part of the state, I would say typically sellers, if it's just an everyday residential transaction, sellers are probably going to use the attorney that the buyer hired to prepare their forms for settlement. If you're doing a commercial transaction, or if you're dealing with an estate, for example, it's not uncommon for the seller to come with their own representation. So just keep in mind, a lot of it may depend. But guys, bottom line, if the seller wants their own representation, they are welcome to get it. They are welcome to hire their own representation. Lindsay, you told me this morning, I think before we started, or maybe when we started, that you're primarily commercial. So correct. Do you get to deal with attorneys then for both buyers and sellers? Yes?
We do, yes. And it is very rare. In fact, we recommend that the parties never use the same attorney because there's so many things that can go wrong.
There's so much involved. Yeah, absolutely. Absolutely. I think I said involved. You said go wrong. I think we
and there's so, and just when you think it's a perfect there's no such thing as a perfect
no such thing. Yeah. And commercial, you're just a lot, like you said, you're just a lot more in depth. There's sometimes more at stake. Your dollar signs are bigger, you know, your sales tags and stuff. So again, the more complex the transaction, but even the whatever the easy one is, the buyers are welcome to have their own representation, but that would be up to the seller. So we go under contract. We need to, if we haven't decided on an attorney yet, we need to do that. Get your buyer to decide on an attorney. The attorney, once we go under contract, the attorney is going to require certain information. Guys, bottom line, if the attorney's asking for it, just help them get it. Let's not question them. Why do you need this? Just help them get it. They're asking for a reason. If you're working with the buyer, they may communicate with you. If they're working with the seller, they may communicate with you. One of the first things we're going to do when we go under contract is send the contract to the attorney. Let's go ahead and schedule closing. When we signed the contract, didn't we agree on a settlement date? Didn't we agree on the date to go to closing? Now, fingers crossed, everybody needs to be reminded, and we need to share with our buyers that delays in settlement happen sometimes. They just happen. Always have your people have a plan B. Everybody's going to work really hard to close on this date. But in the event it doesn't happen, what's your plan B? I don't want my buyer showing up to settlement in a U-Haul truck. I get very nervous about that. Like, what are you going to do if the attorney loses power? Where are you going to sleep in the U-Haul truck tonight? So just make sure they have a plan B. But we need to get that contract to the attorney as soon as we can after contract formation, so they can start doing their thing and we can get settlement scheduled. The attorney may request a copy of the deed from the seller. They should be able to find that one on their own. But again, if they request it, just see what your seller has if you're the listing agent. Title information, title insurance, we're going to talk about again. Some of this stuff they may be able to find, they just may ask the seller for. So just work with them. At some point, the attorney's going to need the seller's loan payoff. The lender, the seller's lender, is going to calculate their loan payoff to the day of settlement. So they're going to cover like interest to today. They're going to cover everything that seller owes. Again, if we're scheduled to go to closing and closing gets delayed, then we need to request another loan payoff, right? Because it's going to be a different amount, even if it's 2 days later. So the attorney will work with the seller to get that information. And then any invoices that are to be paid at closing. This is one of the biggest places that I learned that not everybody does things like what we do here in the Triad. Here in the Triad, a lot of our home inspectors, for example, will allow the buyer to have the home inspection done and pay for it at settlement. So they'll go out and do it. Now they're going to request a credit card to put on file just in case, right? They got to protect themselves. But a lot of our home inspectors here will go out, perform the home inspection. They're going to send you and the buyer the inspection report. We'll talk more about the inspection in just a second. But they're also going to send both of us the invoice. If you as the agent get that invoice, you need to forward that on to the attorney so that can be added to the settlement statement so the home inspector can make sure that they get paid at settlement. Does that make sense? So any invoices that we get, we need to make sure we send to the attorney. Bottom just fell out. It's coming down. As we mentioned earlier, delays in settlement just happen. As a matter of fact, they happen so frequently that we have a built-in delay in our offer to purchase and contract. So we'll see that next week when we look at chapter 11. Does anybody know how many day delay we have built into our contract? How many day delay? Dory's got it. There's a 7-day delay. Now, you may be looking at your book right now and it says a 14-day delay. That changed last July. So July, what was last year? July 2021. They changed it from 14 days to 7 days. So the forms that we look at obviously are going to be up to date. But if you're in your book and you're looking at page 460, it probably says 14. So make yourself a note to change that to 7. And if you were on the digital, excuse me, if you were on the digital, you would see that new date reflected. Yep. So 7-day delay now. So let's talk about just some general procedures when working with buyers. May that be as you're working with a buyer's agent, as a buyer's agent or as a seller sub-agent. Now you'll get into buyer agency and seller sub-agency and all that in 301. So I'll reserve that for a later time. But the point here is that no matter who you are working with, no matter what buyer you are working with, may they be your client or your customer, we owe certain duties to both parties. And I think what's interesting about this list is a lot of this applies to whether or not you're working with the seller too. So it's not just specific to buyers, but that's just the conversation that we're in right now. When we're working with buyers and sellers, we always have a duty to discover and disclose material facts to the buyer. We always disclose material facts about the property. If I could word that another way, we never have a reason not to disclose material facts. I tell all my buyer clients and I tell all my buyer customers, I owe them the duty of disclosing material facts. We have a duty to act in a competent manner. A big part of my job is to fill in the blanks on the offer to purchase and contract. But guys, when I'm filling in the blanks, I'm not just haphazardly throwing any old thing in there. The blanks are asking for something very specific. And I need to make sure that I'm properly filling in the blanks of the contract. I always have to act competently. I always have to act in a competent manner in everything. Contracts, of course, is just an example. We have a duty to avoid any undisclosed conflict of interest. Remember, you represent one party to the transaction, and that's where your loyalty goes. And anything that goes against their best interest is a conflict of interest. So make sure you always remember in the transaction who you represent. Still working with a buyer, we have to avoid any improper, fraudulent, or dishonest dealing. We always have to comply with our North Carolina real estate license law and commission rule. I'm going to show you guys where you can always access, somewhere between now and the time we're done, I'll show you where you can always access the current law, the current rule. What we did 5 years ago, what we did 5 months ago, doesn't matter. It's always about the current law and the current rules. So it's important that we know how to access that information. And then we got to treat everybody in the transaction, particularly customers, honestly and fairly. So just some general responsibilities. And like I said, I mean, isn't most of this list things that apply to working with your sellers as well? So please don't think that I just don't want you guys to run away saying, well, I can act improper or fraudulent or dishonest with my sellers because the slide just said working with buyers. No, that's not what we're saying. That isn't a free ticket or anything. We owe that to our buyers. So let's talk more specifically now about the buyer's due diligence period. So we're under contract. Yay! Always do your mini celebration when you get a signed contract in your hand. Don't overdo it because you don't have that thing to closing yet, right? But you can, I'm all about celebrating the small wins, and getting it under contract is definitely a small win. So congratulations, we are under contract. And particularly when we're working with buyers. Now the buyer's agent's job really starts, doesn't it? Up to this point, we've just been going around looking at pretty houses, opening the front door and letting them in. Our job as buyer's agents really start when they say, this is it. This is the one, that's write it up. And hopefully we get them under contract. And once we get them under contract, the first thing that we need to do is get their loan, start the loan process. Guys, without a doubt, hands down, the loan process is the longest part of the contract to closing process, without a doubt. So once you get the contract, we've already gotten a pre-approval or pre-qualification or proof of funds. As Jory said, we're not going to go out and show them property until we have that. Anyway, we shouldn't be out there showing them property until we have pre-approval or proof of funds. But now that we have the contract, the first thing we need to do is send that signed contract to the buyer's lender. If a lender's involved, so we sign the contract, yay, mini celebration, get that thing to the lender so they can start their process. And our big responsibility is to, when it comes to the loan, is to encourage your buyers to get the lender what they need. Here's the deal. The lender has a process. They do this and then they do that, for example. They can't do that until this is complete, right? They got a very certain order, very particular process that they have to follow. So we go under contract. Your lender's going to reach out to your buyer and request information. What are they going to request? Maybe past pay stubs, maybe some invoices, something to do with their debt, right? Who knows what they're going to ask for, but they're going to ask the buyer for more information. We need to keep those gears going and tell your buyers to make the lender a priority. The lender cannot go any further until they've collected what they need to, until they've gotten past that step. Guys, I even tell my buyers, once we go under contract, that you call the lender back before you call me back, because we've got to make that lender priority. We've got to get the buyer. Would it surprise you guys if I told you that there are cases where buyers have delayed their own closing because they didn't get the lender the information that they need? So help keep those gears going. I've had about 2 buyers in my life that they just thought they were going to go at their own pace. And I got the lender calling me going, why won't they call me back? let me give it a try. Hey, please, please, get the lender what they need. So help keep those gears going. If the buyer is using a lender, an appraisal is required, period, end of story. The lender will require the appraisal. What if it's a cash buyer though? Do they have to get an appraisal, cash buyer? No, it's not required. Can they choose to? Absolutely. So if they start asking lots of questions about value and what's it worth and if it's a cash buyer, suggest that they talk to an appraiser. It can't hurt them. But if they're going through a lender, the appraisal is actually the property of the lender. The appraisal belongs to the lender. Now the buyer gets to pay for it, but it's actually the property of the lender because they're ordering the appraisal to determine how much to originate the loan on. And a lot of that comes from the opinion of the appraiser. Questions so far about the loan? Okay. And same thing with our attorney. Your buyers may look at you back at the day at the beginning of your relationship and say, I don't know any lenders. Who should I use? Here's a list of 2 or 3 lenders that I or someone in my firm has used. Once you guys get going in this industry, you'll form relationships. There ain't nothing like having a lender on speed dial. There's nothing like having an attorney and a home inspector, somebody that you can send a quick text to, and you will form those relationships. You just got to give it some time. Something else that the buyer should seriously consider doing during their due diligence is having a survey done. Surveys help people determine their property parameters, their property lines. Surveys also help the lender, the attorney, the buyer see if within those lines, are there encroachments, are there easements, are there setback violations, flood zones. The buyer orders the survey. If something is found on the survey, let's just say the survey identifies an encroachment, for example, it is on the seller to get this taken care of before we get to settlement. So once that survey comes back, if there's any problems, if there's any encroachments or issues, they got to deal with it. Maybe they hire an attorney of their own to take care of it. Maybe they just go out and tear down the encroachment. I don't know what the answer to that is. But if something comes up on the survey, any problems come up on the survey, it's the seller's responsibility to correct it.
So Julie?
Yes, ma'am.
So surveys are not negotiable? It is always the buyer that pays?
The seller may, if the seller purchased it when they bought, they may provide that to the buyer, but the buyer is still always encouraged to have their own done. So even if the seller, because now it's, how old is it? Was it 20 years ago that the seller bought? You know what I'm saying? So even, and I say, even if, I use that very loosely because I've never known a seller to be willing to release their survey.
Well, it happens all the time in Texas, and we do what's called a T47, or the title company does. They review it through their title attorneys to determine whether there's been a new fence done, pool put in, whatever would have changed it. Now they're getting on us about copyright laws.
Oh, geez.
From the survey.
Because it's the seller's property, right?
Yep. And the copyright laws have to do with the ones that did the survey. Well, they're losing money if the title companies keep saying, oh, this 15-year-old survey is good. So
Wow.
now there are some cases in court about copyright.
And that might be where you might be heading to Texas, is your buyers might be encouraged to just get their own. So now you know what the buyer has is theirs. It's their property because they pay for it. They have the invoice. That's interesting, Patricia. Thank you.
So we are encouraging them here, though, to buy their own.
Yep. And that, so, here in North Carolina, surveys aren't required anymore. There used to be a time that they were required, but the lender dropped that requirement. So now they're not required. It's completely optional. And Patricia, it blows my mind how many buyers waive the survey. It blows my mind. I guess they think they're saving money. Y'all, what's $600 in the big picture of buying a dang house? You with me?
Oh my God, so surveys aren't even required here?
No.
Oh my God.
They are highly recommended, but they are not required.
The house next door to me, we have
Oh
a
my
shared
God.
driveway. And the
Shared
person
driveway?
that bought the house never got a survey. So she asked me how much of the yard belongs to her. And my question was, didn't you get a survey?
Where's your survey?
So I could kind of take a little bit more of the yard and the driveway then. And since I plan to be here for another 20 years, I can just put up a post and a fence and
And they have no proof otherwise, do they?
no. And
See, and
then
that's where it comes into play, Vivian, isn't it? So you got two people who have been side by side for 20 years. Maybe they've been sharing a driveway. Maybe there's an encroachment or a fence or a pool, but we've just gotten used to each other over the last 20 years, right? So now either one sell and the new guy comes in and now all of a sudden it's a problem.
yeah. Because
So does the
we got a
grandfather
survey
clause
when
not
we
help?
bought our house. So I know where the line is. But I
Good
could
for you.
move the line, put a
Yeah.
stake there, and in 20 years I'd have more property, correct?
You'd have more property. Yep.
Yeah.
Yeah.
Isn't that something? So, again, it blows my mind how many buyers waive the survey. Guys, I can't make anybody do anything, can I? If so, I've got to figure out how. So to my knowledge, I can't make any, all we can do is recommend, suggest, by the way, I do have another form I'm going to show us. And this is a form where your parties can go through and either select or waive various surveys or various things. Survey is one of them. So that's kind of our protection, right? If the buyer waives the survey, we have them initial that. And then after closing, if they think it's a problem, they can still come back and try to sue me, right? You can sue anybody for anything, but at least now I have documentation where I tried to get them to survey. I want y'all to go ahead and write this down. If you don't have it written down, Vivian, poor thing, probably has it ingrained in her head. Document everything. That's worth me saying again. Document every single thing. I'd hate for you guys to ever get a call from an attorney or the letter of inquiry from the North Carolina Real Estate Commission where somebody has filed a complaint against you. But should you ever get sued, should you ever get a letter of inquiry from the Real Estate Commission, your documentation is what's going to save you. You're not going to be able to call the Real Estate Commission and say, I told them to get a survey. What they want to see is your proof. And that's the form I'll show you guys before we're done. Email, communication, text, all that needs to be saved in the transaction file when you're complete.
That's what I love about having a good back office.
Yes. There's where your admin comes into play again, isn't it? Absolutely. As far as them being, again, for the most part, they're not required anymore. Now, if the lender has any reason to have concern about if the property's in a flood zone, then they may require it. They may make the buyer, but for the most part, it's completely optional. All we can do is just talk about the importance. We'll bring this back up in just a minute when we talk about title insurance too. Another thing that our buyers need to do during their due diligence period is secure property insurance, homeowners insurance. Not all people and not all properties are easily insurable. They can get insurance, but if they're not easily insurable, property owner is going to have to pay for it. We are good that our buyers' pre-approval from the lender is based loosely around how much monthly payment they can afford. And that monthly payment is the principal and interest that they owe the bank, plus part of their taxes and insurance for the year. We'll talk more about that. But if property insurance is more than what they can afford, or more than what they're allowed, what they're approved for, they're not going to get loan approval. So if we have to, we get them shopping around on homeowners insurance early. Again, here's a list of 2 or 3 names, you know, send them Jake to State Farm and what Flo from Geico and, you know, whomever you know for your homeowners insurance. Have them shop around and get that secured while we are still in due diligence. Make sure they can afford it. Make sure it's not going to harm their monthly approval, their loan amount. If the property's in a flood zone, they'll also have to get flood insurance. And I'm here to tell you, flood insurance is not cheap. So if it's in a floodplain, a flood zone, they may have to get that. And again, if it's going to push them up over, then they're not going to get that loan approval. HOAs as well, absolutely. So early in the process, let's get our buyers shopping for homeowners insurance and get that secured so we can make sure that they can afford it. The big part of the buyer's due diligence is performing inspections and inquiries on the property. One place that your buyers can always start, most of the time they can start here before they ever see the property, can't they? But we can get their hands on the residential property and owner's disclosure statement, RPOs. That's what I like to call this, Residential Property and Owners Association Disclosure Statement. This is the form, this is the seller disclosure, where the seller goes through and says yes, no, or no representation. While the buyer shouldn't rely solely on the RPOs, this is a good place for the buyer to start. And again, here in the triad, the majority of the time, when you look at a listing, when your buyer says, I want to see 123 Main Street, and you go into MLS and pull it up, the majority of the time, the RPOs is there and available. So if something, you can send this to your buyers before they ever see the property. Make sure they don't have our flags go up before we ever pull in the driveway. Remember what we said there, you guys. I always have a duty to disclose material facts, regardless of how the seller completes the RPOs. If the roof leaks and the seller says, no, the roof doesn't leak, or better yet, the roof leaks, shh, don't tell anybody, and they say no representation. Once I find out that roof leaks, I have a duty to disclose that. It does not matter how the seller completes the form. Everybody hear me? The roof leaks, shh, I'm going to say no representation. Don't tell anybody. I'm sorry, Mr. and Mrs. Seller. My licensed law and commission rule says that I always have a duty to disclose material facts. And again, you guys, even with the seller completing this, the buyer should be encouraged to do their own inspections. Please don't let the RPOs, oh, well, the seller said everything's fine, so there's not a problem. There's something wrong with that house. There is no such thing as a perfect home. So even if the seller says, no, nothing's wrong, still encourage them to have their inspections. They don't know. The other thing I want to say about the RPOs, you guys are all licensed now. Have you been getting the monthly e-bulletin from the Real Estate Commission? You should get an email once a month. They're spot on, like the first of the month. And one thing in that e-bulletin every month is the disciplinary actions. And I'll tell you one thing, a common theme I've been seeing lately in the disciplinary action is about this form. And what I'm seeing is if something changes throughout the listing, we need to get the seller to do an updated form. So if the seller says, no, this isn't broke, and then it breaks, we need to get the seller to update that on the RPOs. Is everybody good with what I'm saying? If something changes in the condition throughout the listing and the contract, throughout your time together, and I'm seeing that quite a bit on the disciplinary action, agent failed to keep the RPOs current. So please don't be a statistic in the disciplinary, in the bulletin, right?
So is there a page that says updated seller's disclosure or some type?
Nope, you just have them do a new one and load it in, send it to your buyer if you're under contract, right? Make sure that they see it, let them know. But yeah, if you're getting an MLS, the only thing you'll have is that you'll have a different date that the seller signs it, right? So if they signed it 6 weeks ago and then sign it again today, and of course you're always going to keep previous versions, right? Because we document everything. So you'll be able to have that change, see that change. Another thing buyers should consider inspecting is we call it a pest inspection. The pest inspection isn't inspecting all pests though. Particularly what they're looking for are those that destroy wood destroying insects. So they're looking for termites, powder post beetles, carpenter bees, things like that. Again, the only time that this is required is if your buyer's getting a VA loan. VA almost always requires the pest inspection. Here's the kicker. VA very rarely lets the buyer pay for it. So who would be on the hook to pay for the pest inspection? If the buyer's not allowed to pay for it, are you going to pay for it? No, you're not going to pay for it. There we go. So if the VA won't allow the buyer to pay for it, then usually the seller's going to be on the hook to pay for it. As a listing agent, is that important to discuss with your seller when they're considering an offer from a VA buyer? Absolutely. We got a form addressing this. This is one of the forms that we'll look at in chapter 11 when we get there. So we'll see this again. What the pest inspection does, again, they look for visible evidence of insects. They're not necessarily seeing the insects themselves, but they're looking for visible evidence. So example, what you guys are looking at here are termite tunnels. Termites build these tunnels to get from the ground up the brick foundation to the wood of the home. This one is inactive because you don't see anything crawling around in it. I have seen these things with things crawling around in it, and I hope that I never see it again because it's like one of the creepiest things I've ever seen in my entire life. They're not necessarily looking for the insects. They're looking for evidence that insects are or have been there. So when they see something like this and they would point it out, if they see evidence of other pests, non-wood destroying pests, they will, of course, and then home inspector too, of course, will fill that out. We'll notify the parties. But again, what the pest inspector is particularly looking for are those that destroy wood. Another thing our buyers do during due diligence is they're having the home inspection done. As we mentioned earlier, there's no such thing as a perfect house. And with that being said, you guys, the home inspector's job is to go in the home and point out all the problems. This is broke, this isn't working right, please prepare your buyers for this. The home inspector is not going to go in there and ooh and ah and talk about what a pretty house it is and what a good deal that they got. That's not their job. Buyers need to be prepared. There's going to be problems. There's going to be things that the home inspector finds. I tend to think of the home inspector as kind of like our general practitioner. You know, hopefully we're going to the doctor once a year for a checkup. But when they find something that causes an alarm, they send you to a specialist, right? They send you on to talk to somebody else. The home inspector is kind of the same way. They know a little bit about a whole lot of things, but if they find a problem, they're going to recommend that you talk to a specialist. This electrical isn't working, call an electrician, call a plumber, call a general contractor. Usually that's what you see. The recommendation of the home inspector is to have somebody else, the professional, come in. When it comes to educating our sellers, you know, as the listing agent, I think one of the best things we can do with our sellers is have this conversation. The home inspector can't come in and touch the seller's stuff. So if they have boxes piled up in front of the closet with the water heater isn't going to get inspected, right? The home inspector is not going to move those boxes. So sellers need to make sure that they have the water heater and the fuse box and, you know, all the components of the home where the home inspector can get to it and inspect it. All of this whole home inspection and the pest inspection and everything we've talked about so far should all be done during the buyer's due diligence period. In North Carolina, we'll talk more about this in chapter 11 when we get in our contract, but just to make sure we're all caught up right now, the due diligence period is the buyer's opportunity to learn as much about the properties they possibly can, and then decide, now knowing what I know, do I want to move forward with or terminate the transaction? So if we have a really bad home inspection report, it's just page after page after page, and the buyer decides this is like $30,000 more work than what I wanted to deal with, that home inspection might give them what they need to decide if they want to terminate or move on with the transaction.
Julie,
Yes.
as houses were selling so quickly, not as much now, but say 6 months ago,
Mhm,
inspectors were backed up 3-4 weeks.
mhm.
So is there wording you can put into the contract to with about the due diligence based off of an inspection or something?
Well, remember, I can't create verbiage. I can only use what I got. So what I'm going to have to do is try to negotiate a long enough due diligence period. So if you know your home inspector is 4, 5, 6 weeks out, then you need to try to negotiate that length of time of due diligence. But I cannot add a provision that says, you know, we need time to do due diligence, right?
The-
If you wanted to do
the
that,
buyer.
then we'd have to, yep,
The buyer,
So-
can the buyer do
Yep.
that?
yep. Buyer could do that, yes.
Okay.
But again, just kind of, because in this market, that's not going to be appealing to a seller, right? You know, if you're asking for 6 weeks in this market, your buyers better be willing to ante up some due diligence fees, some due diligence money, right? But it's all negotiable. And you know, one thing I've learned is that money talks. How do you get somebody to give you 6 weeks? Give them some money. Money talks. So there's, I guess my point, Vivian, is there's ways we can work around that. I do agree that things were a little harried there for a while. It's starting to normalize a little bit. Home inspectors are getting caught up. There were cases of buyers in the last 6 months to a year that were just waiving the home inspection, just telling the seller, I'm not going to get it inspected. I could not imagine advising a buyer not to get a home inspection, you know, but buyers were in this market, they were just desperate. I don't know another word to use. They were just desperate, and waiving the home inspection got their foot in the door. Not a good market for buyers. Definitely not. So if we go back to the Real Estate Commission's website, again, publications and publications. I just love these Q&A brochures. When you're working with a buyer, maybe a first-time home buyer, even a seller, we have a Q&A on home inspections. So you can find this again, the Commission's website. Again, you guys, why are you recreating the wheel? When your buyer says, what exactly is in a home inspection? Ta-da, here it is. Go get them the PDF or fork out the 30 cents and buy them a brochure and have this information for them. This is why we have this available, so we can help better educate our clients. Questions or comments other on the home inspection?
Okay, so the due diligence. In Texas, we call it an option time,
Okay,
but here it's.
hang on to that question, because we are
Oh.
going to cover all of that in chapter 11. So I know you guys coming from other states, we got to fill in the pieces to your puzzle, right? So just bear with me. Chapter 11 is all about our contract and our due diligence. Yep. Anything else so far? Also prepare your buyers, you guys. Home inspectors like to use lots of pictures, and pictures just take up space. So if they see a 40 or 50 page home inspection report, it's okay. A lot of it is probably pictures. So I think especially a first time home buyer, things that we can help prepare them for. I mean, you know, if you knew nothing about this and you got an email with a PDF and that thing was 60 pages and the inspector said everything looks good, What about this is good? I got 60 pages of problems here, but they use lots and lots of pictures, big descriptions, that kind of thing. So just prepare your buyer 70 pages, and it wasn't that bad, was it? It was just a bunch of pictures, and your buyers probably went into a little mini freak out, mini panic, but it's okay. This isn't so bad now that we actually go in and look at it. Thank you for sharing that. Other things that your buyer can be doing, and I think what we can help them with too, is just look for stuff, physical inspections. Are there tenants in place? Hopefully, if there's tenants in place, the listing agent is letting us know. In North Carolina, if a buyer buys with an existing tenant, an existing lease, they buy honoring that lease. They buy honoring that tenant. That would be an assignment, wouldn't it? The lease would change. All the terms would stay exactly the same. The only thing that changed in this case would be the name of the landlord. Once the buyer buys, they become the landlord, and the closing attorney can absolutely help us drop another lease. While I'm not a surveyor, I can try to be on the lookout for easements and encroachments. Like Vivian said, she knows her property line runs down her driveway somewhere. She may not know exactly where it is. She does because she has a survey, but her neighbor may not know exactly where it is. But you can kind of eyeball it and make sure, is there anything on this line or close to this line? Again, if there's any questions about easements or encroachments, they're going to have to get a survey. I'm not a licensed surveyor. I cannot interpret or answer these questions. I cannot provide that advice. So when in doubt, they need to consider having that surveyed. My husband and I just bought this house 2 years ago. And when we bought the house, we had a survey done because I'm a pretty good real estate agent. So I said, yeah, of course we're going to get a survey. But part of the reason why I wanted to get a survey done is because I had a concern about our shed. And to me, to eyeball it, the shed looked like it was awfully close to the property line. And I wanted to make sure we had this resolved before we purchased the property. So we had the survey. The back corner of my shed is in by a whopping foot. But you know what? It's in. And if any of my neighbors want to come knocking on my door saying your shed's on my property, no, I got a survey that tells me that I'm okay. So I not only protected myself for the closing, one, I needed to know, right? We'll make sure my shed was good. I do not have much wiggle room back there though, do I? So if I wanted to extend on the shed, I probably wouldn't be able to do that corner. Other things that we can help our buyers look for is recent construction or renovations of the property. Ask questions. If you feel like a room was added on later, it probably was. If you notice a lot of fresh paint or recent work, ask some questions on behalf of your buyers. Make sure that, for example, all the mechanics were paid from those renovations, that there's not any outstanding mechanic liens out there that can later affect the property. Also help your buyers with zoning and restrictive covenants if you're in an HOA. We should be able to rely on the zoning and MLS as long as we have no reason to think otherwise, or if your buyer has a particular need. If your buyer says, I want to convert my garage to a hair salon, now we need to make sure, despite what the zoning and MLS says, I have a duty to make sure for myself that they are allowed to convert that garage into a hair salon. Is it allowed for residential and commercial use? Same thing, what we get here a lot in Archdale. Can we have chickens? Well, honestly, it depends on where in Archdale you are. But if my buyer thinks they want chickens or goats or whatever, then we need to help them verify that in the zoning. Same thing with restrictive covenants. If they're in an HOA, we need to get the covenants in their hands so we can help them make sure that what they want to do is allowed. Guys, the only thing you know by looking at a fence is that somebody put a fence there. I don't know if it's on the property line. I don't know if it's affected the property lines. I don't know if the HOA allows it. Just because the neighbor has a fence doesn't mean the HOA allows it. They could be in the throes of the legal battle to have the fence removed. So if your buyer wants I need to buy a house where I can park my RV in the driveway. All right, let's check the covenants. Make sure you're allowed. Make sure you're allowed to have a fence or a shed or whatever. Daycares, yes, Patricia, that's a huge one right now, isn't it? Especially, I think, post-COVID, a lot of people want to run daycares out of their homes, and that's fine as long as zoning and covenants allow it. When I'm working with buyers, I tend to operate by a pretty simple philosophy. Makes sense to me. If it's important to my buyer, then it's important to me. They say, I want a daycare and I want chickens. Then to me, the most important thing is making sure that they find a property where they can run a daycare and have chickens. Everybody with me? And that's where we need to help them verify the zonings, the covenants, etc. We are helping them learn about the property. Remember, the whole point of their due diligence is to learn everything that they possibly can. We are helping them. If it helps, consider us fact finders. We are fact finders. We're helping them gather the information for them to make an informed decision. Sewage disposal systems, obviously, if it's public sewer, not a big deal. The concerns come in if you have an on-site septic system. So there's a couple different things here. If your buyer's buying unimproved land, bare land, it's not been plumbed, there's no electrical, there's no internet, nothing, just dirt. One thing they're going to want to do during their due diligence is have a PERC test, P-E-R-C, to make sure that the land can support an on-site septic system. Now, obviously, this is if it's not going to be hooked up to public. But they're going to want to have that PERC test to make sure that the soil, the land, will support an on-site septic system. Is there a certain location that the septic system needs to be? And what's that relation to where the house is going to go? The structure is going to go. If it's improved property, it's already been plumbed, electrical, utilities. If an on-site septic system is already in place, your buyer should be encouraged to have the septic tank inspected as part of their due diligence. Listing agents, you need to prepare your sellers. Do y'all know how they inspect an on-site tank? They show up with the backhoe and they got to dig it up. They got to get to the tank to inspect it. Now they'll put the dirt back on and pat it back down when they're done. But nothing, if sellers don't know this and the dude shows up with a backhoe, nothing much sends them into freak out mode faster than. So let them know. Who remembers with on-site septic systems, the permit, the improvement permit comes from the county health department. So whatever county you're in, just call that health department. And one thing that the septic permit, the improvement permit will tell you is the number of bedrooms. Who remembers how many human heartbeats are allowed per bedroom? Human heartbeats. This is not our four-legged friends. You guys remember how many human heartbeats, human family members? No? They say to figure 2. That's right. 2 human heartbeats per bedroom. So if, for example, the permit says it's a 3-bedroom house, that means the septic tank will support 6 people living there. Everybody with me? And guys, we're not just talking about sewer water. We're talking about all water that leaves the house, dishwasher, laundry water, right? All water that leaves the property. If you put in more than 6 people, the system's going to overload. You may have to clean it out more frequently, more often. It's not meant to support that kind of capacity. Listing agents, you can only list the number of bedrooms as stated in the septic permit. So if you're listing a property, that's on an on-site septic permit and it says it's 3 bedrooms, and your sellers tell you you have 4, they have 4 bedrooms, we can only advertise the number of bedrooms as allowed. So despite what your seller says, that thing is a 3 because that's what the improvement permit says.
And what did you call it, Julie?
It's an improvement permit or a septic permit. Another one of those things that has a couple different meanings. There are cases of people that bought houses. I mean, my team ran into one last year. They bought a house, I don't know, 15 years ago, they bought a 4-bedroom. My teammate shows up to list the property, looks at the septic permit and says, we can only list this as a 3. The sellers were hot. Could you blame them? I mean, they bought 4 and now they're being told they have to sell 3. They bought under false pretenses. That thing was under a septic permit. And that's, guys, this is one place that the commission is coming down on me and you. Again, this is something I'm seeing in the disciplinary action. Agent failed to advertise the number of bedrooms as stated on the septic permit.
Mm.
There's been many a times I've been with buyers looking at property, 3-bedroom house, and we're standing in what could be a perfectly good 4-bedroom, but the MLS is calling it an office or a bonus room. You want to know why? Because the septic permit says 3. Everybody good with that? Again, I'm trying to keep you guys out of the bulletin. Questions on that or comments? You got to get your hands on that permit. And if the seller doesn't have it, call them, have them call the county health department, order one, because you know a good buyer's agent is going to ask for it. So let's go ahead and get them started on that process to get that, so we know how many number of bedrooms to advertise. If the property is on well water, the buyer may want to consider having a well water test. They can get a sample of water, send it off. This isn't specific about well water, you guys, though. If they want the tap water, the city water tested, they can as well. I've had a couple buyers now. Interestingly enough, both of them worked in the healthcare division. Buying a house, they say, well, you're on city water. I want to have this tested. So if it's important to my buyer, it's important to me. And if they want to have the quality of their water, well water or public city water, that's absolutely within their rights. As far as septic and water tests, the VA buyer may be required. The VA may require, that may just depend, but usually those are optional. I did have a VA buyer once. We were on well water and on-site septic, and the VA said, yeah, you guys got to get this. You got to get this tested. Lead-based paint, possible lead-based paint. Anything built prior to what year? Who remembers that magic year? Yep. Yep. Anything built prior to the magic year of 1978. This is another form that we'll look at. We'll look at a lead-based paint hazard addendum when we get back to chapter 11. I think it's important that we understand that this form does not say your home was built prior to 1978, it has lead in it. That's not what that form says. The form says because your home was built prior to 1978, it may have lead in it. Buyers are encouraged to have that inspected if they want. Again, prepare your sellers for this. In order to test for lead, they got to come in and chip up a sample. So now they're at usually the windowsill or the door frame, and they're scraping, getting a sample so they can send it into the lab and have that tested. Prepare your sellers. And I think it's important. There's lead-based paint addendum for homes for sale. There's also available for rent. Again, tenants may not be able to do the inspections, but they still need to be knowledgeable, right? Especially if they have young children. I think we'll remember that lead mostly affects those young developing organs. That applies to pregnant women as well. So tenants absolutely have the right to know, to be educated about possible lead in the home. Anybody in property management? I know Lindsay's commercial property management. What about residential property management? Patricia's not even a little bit. Okay. I hear you. Vivian, Jory, we're going to do sales. So I think most of us are, gravitating towards sales, but just in the event you do go off in the residential rental world, lead-based paint isn't going to go away. So you can still bank on that. And you don't have to deal with this at all in the commercial world, do you? Because this is just for dwelling. So, yep. What else can the buyer inspect during their due diligence? Radon. Radon is everywhere. Radon is regulated by the EPA, Environmental Protection Agency. They say any radon level over 4.0 picocuries is considered undesirable. So radon, first off, is a gas that comes from the ground. It's odorless, it's colorless. The only reason you know it's there to have it tested is to have it tested. It is the result of decaying matters in the ground. So as things in the ground break down, they release gases. Those gases look for cracks in the ground to escape. And if one of those cracks happens to be underneath your house, the radon levels escaping into your home. So buyers can have radon levels tested. Around here, most of our home inspectors are certified to test for radon. So you can get the one to do both. The home inspector will come in either before or after their home inspection, whatever their process is, and they leave this contraction in the home. And this contraction, it takes like a snapshot of the radon level every hour. So every hour it says, this is the radon level. And after about 2 or 3 days, the home inspector comes back and collects it and he gets an average. If the average is more than 4.0 picocuries, we have a problem. If it's under, the EPA says that is just fine. If they find radon, and we, either buyer or seller, either party, put in a radon mitigation system. What this system does, it drills until the lowest level of the home. And then there's this pipe that comes out of the home, it runs up the side, and it takes the gases from the lowest level and it pulls it up the side of the house and out into the atmosphere where this radon belongs. The problem with the radon mitigation system is it requires a couple different fans to pull that air out, and those fans don't last forever. My point is, even if your buyers are looking at a home that already has a radon mitigation system, we still may want to suggest that they have it tested for radon, just in case. I had this come up with buyers 5 years or so ago. There was a radon mitigation system in the basement. We stood there, we pointed at it, we had a conversation about it and everything. They decided for them it was worth $130 to get it tested for radon. It came back at like 6 or 7 something. I called the listing agent called the seller called their radon guy. He came out, that's exactly what happened. The fans had stopped working. So that pipe, there was nothing pulling that air out through the pipe. Replaced the fans, had it retested. Now we're back down to 2 point something. The real estate commission says the fact that you have a mitigation system is not considered a material fact. But when and if you see a mitigation system, it should put up a flag for us to ask some questions. And if you're working with the sellers, one of those questions may be, when was the last time you had the little fans tested? When was the last time you had this looked at? Most of them have a warranty, but if they don't know the fans aren't working, they don't know what to fix. Comments on radon?
So the fans, the mitigation system for radon is not considered a material fact?
Correct. Just because you see a system is not considered a material fact. What it is though, is it should raise a little red flag for me and encourage me to ask more questions. Some builders are building homes today with mitigation systems in them because a lot of our new construction today is so dang tightly sealed that air isn't getting in and out. And that's what radon needs, is ventilation. It needs to be able to move. So you have this new construction that's like air sealed and it won't let any gases out. So some builders are combating this before it ever becomes a problem and just putting them in when they build. I think vacant homes tend to have a little higher radon level because homes are meant to breathe. They're meant to have doors open and close, windows open and close, AC units kick on and off. You guys know what I'm saying? So if it's vacant, you're not having those doors open as often. You're not having the AC kick on as often. So vacant homes tend to have a little higher. I've heard you can go to like Lowe's or Home Depot and get a home radon test kit. I've not really looked into it, but if you're sellers or buyers, I mean, I don't know, that may be something, a good place to start. But you know, you may want to do some research on how accurate they are, the validity of them, that kind of thing. Another thing buyers should consider inspecting is asbestos. We'll do this and then we'll go to break. Asbestos, again, was one of those things that was built in building products in 1978. Now, you don't need to know that year like you do for lead-based paint, but isn't it helpful that it's the same year? So thank you guys for that. So 78, anything built after 78, you're probably not going to find asbestos in it. Anything built prior to 78, you might. Asbestos isn't a problem until it becomes friable. As long as it stays intact, it's not the issue. The issue is when it becomes friable. What happens is it becomes friable and the asbestos breaks down and those little particles get in the air, and then we breathe that air, thus those little particles get into our lungs. So we have looking at respiratory problems. I think the buyer that really needs to be aware of this is the one that plans on doing major renovations, possibly even demolition after they buy. So it's not my job to go in there and say there's asbestos in this home. But if I know they have major plans to do renovations or demolition, and I know it's built prior to 78, I may suggest that they consider having that looked at. I don't know if there's asbestos in there or not. I'm not an asbestos expert. Is that a thing? An asbestos-y? No, I don't know. There's got to be a name for that person. Obviously not me, right? Just help give them that knowledge. Questions? All right, so let's take our break. Let's take 10 to 51, and please note the time. So 10 minutes, come back at 2:51, and we keep going in unit 14. So Jory, did you get that? You got your seller under contract? That's what happened earlier?
Well, we still haven't accepted yet. I did call them. There's a lot of blanks on the offer to purchase, so I told them to fill out the rest before we sign anything.
Good for you. Good for you. So I guess next time we see you on Wednesday, you'll be under official.
Well, I'm under contract for another property and I have an appraisal on Wednesday. Hopefully it goes well.
Usually in this market, again, things have been a little bit different, but typically we just don't do much with appraisers. You know, every once in a while as a listing agent, maybe the appraiser doesn't have a super key or something. So I may need to go over and let them in, you know, open the door for them, same thing as a buyer's agent. But
Mhm.
usually they just kind of go in and do their own thing and then we find
I'm
about
just worried about like under appraisal because I had one of my listings back in June. It under appraised and that was not a good time for me and my seller.
no. Did you guys get it worked
They-
out? I mean,
Well, they just paid up to 5,000. They didn't close the gap completely, but they paid
okay.
up.
Yeah, and that appraisal addendum gap is kind of like waiving the home inspection. That's something that we've seen the last 4 years ago. The idea of waiving a home inspection was like, you know, and now today, same thing with that appraisal gap. So it's you know, different markets just bring in different challenges and different things. So all right. I think Vivian's around. It looks like she just stepped away for a minute. So, oh, there she is. And there's Miss Patricia. I know you can get up and walk over the other side. You're there. But see, all we see is like, you know, just our perfect little Zoom box here. And that's all right. So let's take attendance back from break. Okay, so we're still on the buyer's due diligence process. We've been through a slew of things that they should consider. Maybe they should have it done, maybe they shouldn't. These things aren't required. Remember, we said the appraisal is required if they're getting a lender. There's no ifs, ands, buts about that. If they're a VA loan, the pest inspection is going to be required. A lot of this other stuff is just at their discretion. You know, we can recommend them to do these various services, various inspections. Again, we'll look at the form somewhere between now and our time together that it's kind of protecting us to make sure we have these conversations about these things. So we will definitely look at that form. Those of you new to North Carolina, and again, I know I kind of skipped around our offer to purchase and contracts. So I promise we're going to get back to it. But just in case you guys don't know, now that you're in North Carolina, sellers are not required to do any repairs. Sellers don't have to fix anything. They don't have to disclose. They don't have to do any repairs. Once the buyers had their inspections done, we can always ask the seller to do repairs. There's no law that says we can't ask, but the seller doesn't have to agree to do any repairs. Remember what we said. The whole purpose of the due diligence period was for the buyer to learn as much about the property as they possibly can and decide, now knowing what I know, do I want to move forward with the transaction or not? And whether or not the sellers intend to do repairs, wouldn't that be helpful information to the buyer in making that decision and whether or not to move forward with the transaction or not? I mean, they are now having a 60-page home inspection report in their hands telling them everything that's wrong with the house. And the seller's saying, nah, I'm not going to fix anything because I don't have to. So the buyer's got to take that into consideration, right? What if the seller says, of that entire 60-page report, I'm just going to fix these 5 little things? Again, the buyer, now knowing what they know, decides to move forward with or terminate the transaction. And whether or not we're going to do, the seller's going to agree to do repairs should also be part of the due diligence process. If the seller agrees to do any repairs, first off, as buyer's agents, we say, thank you very much. Understanding that they're under no obligation to fix anything. So if they agree to change a light bulb, we say, thank you. If they agree to do any repairs, these repairs must be agreed on in writing and signed while we are still in due diligence. That's part of the information that the buyer has to decide if he wants to move forward with or terminate the transaction. Here's the problem topic, I think both in practice and 302. The seller agrees to do repairs, puts that in writing while we're still in due diligence. But the repairs themselves don't have to be complete until prior to settlement. All we're getting within due diligence is the seller's signature saying, I'll do it. And once they sign that form that we will look at in just a minute, they're now contractually obligated to change the light bulb or whatever repairs. So we'll look at the forms that relate to this. But I want to make sure we're really good on this screen. Again, I don't think this is just a problem topic for the class. I think this is a problem topic out there in practice. One thing that I've kind of noticed over the last couple of years, and I don't know if it's because of COVID or what, I don't know, but something I've heard several times the last couple of years that really just, I don't know where it's coming from, but I'm on a personal mission to squash it myself. Once due diligence is over, there is no going back. Once we are out of our due diligence period, we can't go back into due diligence. Can I extend due diligence? While we're still in due diligence, can we extend due diligence? Sure, the parties can agree to extend it. Is everybody good with that? I don't know where this is coming from. Once we're out of due diligence, there ain't no going back. The best we can do, the buyer can ask the seller to extend due diligence. Is the seller under any obligation to offer that extension? Do they have to agree to extend it? No. What could make them agree to do it? Money. Money talks. The seller might likely say, you want 2 more weeks? I want $2,000 more, right? Money talks. So we can agree to extend it, but we don't have to. We can ask for repairs, but the seller doesn't have to. So we ask for repairs. The seller says, yeah, I'll do that, signs it. Now they don't have to do the repairs until prior to settlement. The buyer always has the right to verify completed repairs. So they should be done prior to settlement or whatever other arrangements the parties agree to. For example, I had buyers a couple years ago. They were buying a house that was like built in the 60s, a one-owner home. This couple bought this house when they got married. They raised their kids there, right? A one-owner home built in the 60s. We don't see many of those floating around. It was the most well-maintained. They loved that home from the day they bought it. You could tell it. It was a nice home. Once our home inspector got in there, we found problems with the electrical. The parents have passed. The kids are now handling this as part of the state, right? So we find it was built in the 60s. Of course, it's going to have some electrical issues, some issues, right? This was a concern of my buyers. We asked the sellers, the heirs, to do repairs. And the heirs said, oh my gosh, well, look, we really want to help you out, but we're not going to do this because we're done. We're over it. We don't want to do it ourselves, but we want to help you out. So what are other arrangements that we can do? What we ended up doing in that situation, my guys got a quote from an electrician. The sellers took that money from the quote and put it in an escrow account at the closing attorneys. So the closing attorney is holding the electrician's money, right? We go on to closing, keys change hand, deeds change hand. After closing, the electrician comes out and does the work. Only now the electrician isn't sending the bill to the buyer or the seller. They sent it straight to the attorney who paid out of their escrow account. That was the arrangement that those parties agreed to. I just share that story to let you know that maybe it isn't the repairs that's the end all be all. Maybe the parties want to help each other out, but in that case, the seller didn't want to deal with repairs. Sometimes we got to come up with, we call them creative solutions, and help our buyers and sellers come up with things that they can agree on, things that'll work out for them. Again, the thing about this slide I want you guys to see, they got to be agreed on in writing and signed while we're still in due diligence. The repairs themselves don't have to be complete until prior to settlement. What questions do I have on this?
Okay, Julie, so are you saying that, say on the repos disclosure,
RPOs,
or
residential.
RPOs,
Yep,
okay.
yep.
On the RPOs disclosure, a foundation or roofing issue was not disclosed because at that time the seller did not know he had one, right?
Okay.
So during the due diligence period, we find an issue,
Uh-huh.
right? And we have the foundation company come out and they do draw us a diagram or whatever, and the seller is not obligated,
Correct,
right?
correct.
So then the mortgage lender is willing to underwrite a property that has a foundation issue going in?
The
Or
mortgage,
a roof issue, or a roof issue?
the mortgage lender isn't gonna see the home inspection. So
Mhm.
they're not gonna know.
Yeah. If the buyer discloses it to the lender that there is.
Then that may be a different issue, right? That may be a different, and I'm not a lender, I can't answer that. But every transaction I've ever done, the lender, my very first transaction, I had my lender buddy, remember I was admin for like 14 years. So I had a lender buddy, and I thought that was the thing to do. And I sent him the home inspection. He said, I don't want
Right,
to see
right.
that. I don't want to see that, you know?
Right.
So I thought, well, gee, maybe I should send it. So if the lender doesn't know, then they can't, you know, now if it comes out in the appraisal, for some reason, now the lender is aware, right? And they may have an issue, but as far as the home inspection, the lender generally does not see that.
Hmm. Okay, because I know we've actually kind of sometimes, you know, when the appraiser is scheduled, that we would leave the inspection in the house for it to be found. But anyway, I understand. Okay,
Yep. And that may be, I've left reports for the appraiser, like my comps, where I got to the number that I got to. But yeah, not because guys, remember that the home inspection is the property of the buyers. It's the buyer's report. So it's not the sellers, it's not ours, it's not the lenders, it's the buyer's report. So they should be the one to decide who they release that to. And I said, I accidentally showed that to one of my lender buddies. And after that, I've never been asked. It's never come back up with the lender. So unless it comes up on the appraisal. Okay. Earlier, we mentioned restrictive covenants in our HOAs. Again, we just need to help our buyer get that information, particularly if we haven't gotten informed by the time we're writing the offer, then particularly we want to get it for them while we're shortly after we go under contract, so they can look over that and make sure they're allowed to put in their fence or their shed, or, you know, park the RV in the garage, or paint their front door some brilliant color, you know, just whatever those covenants and restrictions are. Here's the key, you guys. Again, I am a fact finder. I help them get the information. I cannot interpret the restrictive covenants for the buyer. So when they say, what does this mean? I either need to get them to an HOA, to the HOA, or I need to get them to an attorney. I am a fact finder. We also, a few minutes ago, mentioned zoning. Is there a particular planned property use? Is there a zoning amendment on the board? We need to be familiar with the market that we're going to work in. I think a lot of our research starts with the county's GIS. So whatever county you want in, I'm here to tell you, every single county's GIS system is different. So by the time you master one county, then you got to learn all new from the next county. They are all, and Jory is shaking her head. She's been there, done that. She knows what I speak of. It can be very frustrating, but once you learn those systems, those different counties, GIS systems, a good place to start with zoning, taxes, property information. Roads and schools. If the roads are public or private, we need to disclose either one, particularly if they are private. The buyers need to know that the homeowners are responsible for maintenance. When I say a road is public or private, I'm not saying whether or not you can drive on it. I'm saying who maintains it. Public roads are maintained by the North Carolina Department of Transportation, or DOT. Private roads are maintained by the homeowners. Is it part of their HOA dues? Do they special assessment whenever they get a pothole? That kind of thing. That's the information we can help them get. And then as far as schools go, when it comes to schools, if I could offer the advice to be the source of the source. So in other words, when your buyers start asking about good school, are these the good school systems? Send them straight to the city or the county school website. Send them to that information. Let them look at those school lines, contact the school board if they have any information. The truth is, you guys, is I don't know your children, and I don't know what school may or may not be good for your kids. So be very careful in answering those questions. Let them do their own research. Let your buyers do their own research. So what we're going to do now, we're going to go off PowerPoint for just a bit. So why don't I pull that back up? So we're going to go. And in Learn, Test, Pass, the folder that we just added, but we also have a folder called Forms. And what Jane did was provide a link to all the current forms. Now, you may or may not know that they updated all of our forms July 1st, 2022. Not all of our forms, most of our forms, July 2022. So it's really important that we always have the current information. So we have the current forms here for you guys. And we're going to go through and we're going to look at, we're eventually going to see most of these, but I'm not going to try not to do this to you all at once. So we're going to look at a couple different forms now related to some things that we just talked about. And the first one we're going to look at is Form 310T. You don't need to know the numbers, but they may help you. And 310T, it's easier, I've learned, if I download it, is our due diligence request and agreement. So let's look at this form first, because this is one we were just talking about. We're going to use this form if the seller agrees to do any repairs. You ask the seller to do repairs, they say, nope, I'm not doing anything. That's their right. That's their obligation, their right as a seller in the state of North Carolina. If they do agree to do any repairs, we got a form for that. Due diligence request and agreement. Think of this form as an amendment. When we look at our contract next week, we're going to see a very important sentence in the contract. And that sentence says, this property is being sold in its current condition. So if the seller agrees to do anything, we've amended that sentence, haven't we? Because now it's no longer being sold in its current condition. Now it's being sold under the presumption that the seller is going to fix this, this, and this. So we're amending the contract between buyer and seller. They've entered into an offer to purchase and contract at whatever the address. And then I have a place here to spell out exactly what repairs the seller has agreed to do. And when we get to this part of the form, I need you guys to be specific. Please don't say fix the electrical. Specifically, what is it about the electrical do you want fixed? Take it straight off the home inspection report. The home inspector is the one that's told you this, this, and this about the electrical is broke. Does that make sense? If you say fix the electrical and the seller signs it, change a light bulb, haven't they fixed the electrical? When probably the buyer wanted, $5,000, $6,000 worth of work done. So be specific. Don't leave any room for guessing. You can, a lot of our home inspectors are using a new program called HomeGauge. I don't know if you guys have seen this yet. It's really cool, but it allows you to piecemeal the home inspection report. So if the buyer just wants to ask for electrical, but they don't want to provide the whole home inspection to the report, you can select the electrical and give your report just with that, and then actually send that to the seller and say, I want you to fix everything. Does that make sense? Everything in this electrical section. My point is you need to be clear. you need to be very clear. Don't leave it vague. You guys know what people will do if they have vague instructions. So don't leave it vague. As a buyer's agent, be very clear what they expect you to do.
Okay, see Exhibit A.
You could absolutely, absolutely. You could say, see attached portion of the home inspection about the electrical. You know, now you got pictures pointing to it. You got a description, right? If you had an electrician follow up, I would attach their report too, right? We're trying to get the seller. We want the seller to agree to do this, right? So we're trying, when we present this, we're presenting it in a way that they have the information right there. Better chance for them saying yes. By the way, in this market, how many repairs do you think are being done? Not many, not many, but you guys mark my words, it'll come back and now sellers have to do repairs, right? So that different market is going to bring different things. Here's a note here. 8 years ago, 10 years ago, I don't know, time gets away from me. Some time ago, they added all these blue notes, and eventually we're going to see a red warning. So when you're looking at a form with a blue note or a red warning, it's meant to pull your attention to it so you'll like look at it. So please don't ignore a blue note and a red warning. Our first blue note is telling us, in lieu of repairs, the parties have agreed to reduce the purchase price or maybe have some seller pay closing costs. Can the parties agree to anything? Absolutely. So the seller might say, I don't want to mess with the electrical, but I'll give you $5,000. Is that something we can work out? Of course it is. So what this first note is telling us that if you make a change in the contract, then we need to use the agreement to amend the contract, which we'll look at next. We need to use that form to change the already agreed upon terms. This note is telling us buyers advised to consult with their lender regarding any agreement to amend. So anytime we're changing terms of the contract, again, we'll see that form in just a second. But anytime we're changing forms of the contract, we may need to get the lender involved. For example, if it's an FHA buyer, they're only allowed, and please don't hold me to this, but I want to say the FHA buyer can only ask for like 3% for seller pay closing costs. So if in lieu of repairs, we're going to do seller pay closing costs, we may need to run it by the lender to make sure we're within that allowable amount. We can't always just be making decisions without knowing the terms for the loan. Here's a release of inspection report. Buyer does or does not agree to release any inspection reports to seller. So again, if they're going to turn the whole report over or a portion of it, we need to acknowledge here. Please remember, the home inspection is the buyer's property. Even though it's on the seller's home, it is the buyer's property. So whether they want to release that or not. And then this agreement shall become effective on the date it's signed. Let's see. So then you have a place for buyer and seller to sign. This is one of the few forms that we have that are still one page. It's tight though, isn't it? We're probably in a change away from a 2-page form, but right now we're still on a 1 page. Any questions or comments about our due diligence request and agreement? Was it 6%? Okay, thank you. Yeah, I was just kind of throwing a number out there. Thank you.
Hey, question real quick. Can you, where on the Learn Test Pass, how did you get to this specific?
So, so down here under forms, next to that bottom category,
Okay.
and then you get a link to the forms. And then that takes you to our Google Drive. You see that?
Yes, I do. Thank you.
Sure. The other one we want to look at is the agreement to amend. Who can remind me, what did we say earlier an amendment was? What did we say an amendment was? If you're amending something.
Modify or make changes?
There you go. You're not adding, you're changing. An addendum adds, yes, an addendum adds and becomes part. That's good. This is why we're talking about this. An amendment is a change. So if I'm using agreement to amend the contract, we're changing something. We are under contract and we are changing something that the parties previously agreed to. They gave us this change in July when they updated our forms, the big change to this form, which is so simple, but so helpful. They gave us this little place. Is this your first amendment, your second amendment, your third amendment? So then that way you have a nice clean paper trail with all your different amendments. Isn't that nice? It's the simplest things that make the big difference. So that was the big change with this form that we had.
Is there a specific number of amendments that can be out at the same time?
No, you can have, yep, we can make as many changes. We can make as many amendments. There is no limit.
Okay, so they don't ever like if there's 3 out there, you don't consolidate them to 1.
I mean, you might want to just for, but you don't have to. And I would think that would be a rare situation. Usually if we're going to ask for 3 changes, we're going to ask for them all at once, but you may have different phases of the transaction, right? So I would try to wrap one up before you start asking for, more changes, right? It's just a matter of getting everybody's signature agreeing to the change. Because remember, we're already under contract. We got buyer and seller under contract. So now we're just agreeing to these changes. Here's our red warning. We're warned that all parties, including lender and settlement agent, must be provided a copy of this agreement. Remember when we went under contract, we sent the lender and the closing attorney the copy of the contract, right? Right when we went under contract. So now that we've changed those terms, we need to be reminded to change with the lender and the attorney as well. So the agreement to amend is between buyer and seller. I have entered into a contract regarding the purchase of the following address, and then buyer and seller hereby agreed to amend the contract as set forth below. We're told to check all applicable boxes. And as you can see there, do we agree to a new purchase price? Do we agree to add additional earnest money? Do we agree to a different building deposit, due diligence fee, due diligence period? These are all terms of the contract that we previously agreed to, but now we're changing, now we're amending. And again, this is a nice change they did. For example, purchase price is hereby amended from this to this. So you can actually see what the purchase price was and now what the newly agreed upon purchase price is. So they made that pretty clear for us as well. If you're changing escrow agents, if the closing attorney, for example, is holding the escrow money, or if the firm, we'll talk about escrow money as well when we get into 11. But if we're changing escrow agents, we need to use the agreement to amend. Also new to this form is this little box right here. If you're changing escrow agents, then we need to get the earnest money deposit to the new escrow agent. So now they have a place where they can sign acknowledging receipt. We need to do that transfer. We can amend the settlement date. If we know that closing is going to get delayed more than our 7 days, we can always amend the settlement date if the parties agree. Again, the parties can agree to do anything. If we change the settlement date, if we amend the settlement date, the new settlement date will also have a 7-day delay, unless you check this box. If you check this box, the new settlement date now has a 4-day delay. Okay, changing the settlement date. Do not check the box, we get a 7-day delay. Do check the box, and now we only have a 4-day delay. They cut back on that a little bit. I took a class a couple months ago with a lady from the Forms Committee. It's really interesting to talk to people that sit on the North Carolina Association of Realtor Forms Committee. And she told us the reason that they change this, that they agree to change the delay to 7 days, is because there were reports out there of agents getting their buyers under contract and then enacting their 14-day delay. And that's not what this delay in closing is for. Well, my buyers get 14 extra days. No, 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 no. This delay in closing is supposed to be if needed. But what these agents were doing was getting their buyers under contract with a shorter closing time to make their offer look more appealing to the seller. And then once under contract saying, well, we're going to use our 14-day delay. So the forms committee squashed that. They took care of that. And it's sad that they came to that, but people were abusing it. People were misusing that 14-day delay. And unfortunately, some people really needed that 14-day delay, but they're not gonna, now they just got to deal with 7. So again, you know, as buyers agents, and that's hard, I know, because like Vivian said, what if you have home inspectors that are booked out for 4 weeks? As buyers agents, one thing we need to take into consideration when we're writing this offer on behalf of our buyer is how much time we're going to need. And that may a lot of times depend on the market. Different markets you need more time or less time for. So just kind of ask your lender, how much time do you need? Ask your home inspector, when can you get out? You know, try to get that information before we go under contract. Another thing we can amend is seller pay closing costs. Right now we're seeing 0, but we're going to come in a time where the seller's agreeing to pay that. So if we do that in lieu of repairs, by the way, all of your forms have a number. So this one is 4T. You guys don't need to know the numbers, but I think sometimes it helps us find the forms. There's a lot of forms out there. There are a lot of forms out there. And then we can also amend the fact that there's a home warranty. If there's a change to the home warranty, maybe that was part of the negotiations, and now we had to come back and revisit that. Buyer signs on the left, seller signs on the right. An amendment is a change. So once everybody is signed, we now have amended the originally agreed upon contract. Questions on this one?
So you don't actually check a box if you want to change the settlement date. You just put in a date. Because that's the only one where you don't check a box.
You would, yeah, that's right. You're right. They don't have a little box here, do you? So you're right. You would just put the date in and then only check this box if you want for 4 days. I wonder if that, I hadn't even noticed that myself,
It
Vivian.
almost
I
makes
wonder
it
if
seem
that
like
was
it
on
wouldn't be
purpose or
valid.
accident.
Mhm.
You're right, because everything else you say, I never even noticed that. But yeah, so I can't check a box if I don't have a box. I bet you we see that in an update. Somebody's on the phone with the forms committee right now going, you don't have a box. It's probably just an oversight. Good observation. The last one we're going to look at for now is there we go. The last one we're going to look at for now is our additional provisions addendum. So now we're looking at an addendum. So now when we see the word addendum, we're going to see the word add. So this is the form that we will use when we're presenting the offer. And of all the addenda that we have, this is probably the most common, the most popular form. So this is the form. These are provisions that are common, but they're not common enough to wind up in our offer to purchase and contract. So they're popular, they're common, but just not quite enough to get a place in our contract. So additional provisions addendum, property address, buyer and seller. All of our addendum tell us that it's attached to and made part of the offer to purchase and contract between buyer and seller. Then we're told all the following provisions marked with an X shall apply. Those provisions marked NA shall not apply. And then as you guys can see, I have a whole slew of additional provisions. First off, probably one thing that we're seeing a lot in this market is the expiration of offer. If the buyer wants to put an expiration date on their offer, They can use this. Offer is going to expire on this date and time, time being of the essence. That means it's a drop dead date and time. If we don't have acceptance by this date, this time, then the offer is expired. If we don't have acceptance, here's a provision we can use if the property has a septic system installation or modification. As part of the buyer's due diligence, they intend to obtain an improvement permit or a written evaluation from the county health department for a ground sewage system. All costs and expenses of obtaining the permit are on the buyer unless otherwise agreed. Seller's responsible for clearing that portion of the property in order for the county to come in and do their inspections. So if they have a bunch of flowers or a tree or something on the ground, then they may need to look at that. Rental income, if it's an investment property and there's a tenant in place, property shall be conveyed subject to existing leases. Seller shall deliver to buyer on or before this date, and buyer wants it all, don't they? They want copies of existing leases, rental agreements, tenant notices, written statements of oral tenant agreements, etc. This form also addresses what's going to happen to that security deposit. Remember, if a buyer buys, they buy honoring the existing lease. So today the landlord is the seller, we go to closing, and tomorrow the landlord is the buyer, right? So the buyer will need to have, the new owner at this point, will need to have possession of the security deposit. So how we're going to handle that, is it going to transfer or not? We will talk a little bit more about that in this class. Probably the other big thing that this form is used for is agreed upon repairs and or improvements. So let's talk about this for a minute, make sure we're good. Remember, this is an addendum, which means we're providing this form when we present the offer. We're not even under contract yet, and the buyer's already asking for repairs. If you have a buyer that is determined, I'm not buying this home with this, or if that's broke, or if this isn't fixed, then we use this form. The seller needs to take this into consideration when deciding on the buyer's offer. I've known of this to be used for so many occasions. I myself used this once. I had buyers, and the out back in the backyard had a really nice playground. Whole lot of fun. All, you know, my buyer, all three of us wanted to go play. I mean, it just looked like such a good time. The problem with that is my buyers didn't have kids. So this playground was absolutely useless to them. They wanted their guard to go there. So we used this form and requested that the seller remove the playground prior to settlement. Let's say you have a window that's cracked, maybe a rock from a lawnmower hit it, and it's got a crack and it's starting to spider out a little bit. We could request that that window be repaired. Again, you guys, this is very important. This is very important. We're presenting this, we're asking for this repair at the time we're making the offer. Everybody with me? This does not negate the buyer's due diligence. They're still allowed to have all their inspections done once we go under contract. They can still ask for repairs. But if there's something that the buyer wants and it's a deal breaker for them, like I'm not buying this house with that cracked window, then this is the form that we use to get the seller to agree upon contract formation. Vivian, did you have a? No? Okay. What questions do we have about this? Buyer always has the right to verify. Let me say one more thing about this. Because this adds to and becomes part of the offer to purchase and contract, the lender is going to see this, and the lender is going to share this with the appraiser. And the appraiser may not be able to give their final findings until whatever is in here is fixed. So you may even want to put a date in there. Seller agrees to do it by this date, so we don't delay the appraiser, delay the closing. Does that make sense? Because once the appraiser sees this, they know it's an agreed upon repair. I had a student in post licensing once. He's down in the Fayetteville area, and I'm not sure why, but apparently in Fayetteville, they have problems. Sellers think that when they go under contract, they're done. They don't have to mow their lawn anymore. And sometimes you go like 6 weeks from contract to closing, and grass can grow pretty quickly in 6 weeks, right? So this guy was starting to use this form for everything. Seller to maintain lawn care until closing. I said, well, that's pretty, that's pretty smart right there. If you know you have a problem, like apparently they do down in Fayetteville area, then absolutely you can use this. Just remember, the attorney, not the attorney, the lender will see this as well, and the appraiser will see it. So we want to make sure everything is, so the appraiser can give their opinion. Everybody good with this? The difference in the agenda and the due diligence repair request that we looked at. One, we're already under contract, we're amending it. This one, we're forming a contract.
So that also does not mean that the buyer cannot still do their own due diligence as far as getting professional.
Absolutely, absolutely. So once we go under contract, they're still encouraged to have all their inspections and investigations done. They could still ask the seller for repairs. The seller can agree to do them or not. That doesn't change anything once we're under contract. Yep. If the property has a manufactured or mobile home on it, we want to identify it here. And then if there's a property with an outdoor pool or spa, how that inspection or the preparations for inspection. Obviously, if you're buying a house with a pool this time of year, it shouldn't be a problem. The pool's still probably open, right? But if you're buying a house with a pool in like February, it's probably been winterized. So now the question is, how can I get it unwinterized to get it inspected? And we can use this form. Any costs associated with putting it in order, and any costs associated with re-winterizing it shall be the responsibility of, and we just have to select who's going to be responsible for getting it ready to winterize it or not. Buyer signs on the left, seller signs on the right. Questions? We've looked at 3 forms so far. All right. Still just plucking right away at our due diligence, getting closer and closer to closing. One thing that our closing attorney, one of their big responsibilities is to perform the title search on behalf of the buyer. Remember, the closing attorney, the buyer is their client. The buyer hires that attorney, so that is the buyer's client. And the attorney has a duty to their client to make sure that what they're handing their client is clear marketable title. And where they're going to start with that duty is to perform a title search. Usually they do a very big, very large, detailed title search shortly after we go under contract. So once they get their hands on the contract, they may go ahead and perform that title search. If they find any issues with the title, then the attorney will get with the seller to clear those up before settlement. It is the seller's responsibility to clear up any title issues before settlement. And the attorney, as a representative of their client, the buyer, they will get with the seller and make sure that they get that cleared. In the title search, what the attorney is looking for, well, they want to find good record of title, want to make sure there are no encumbrances, any deeds on the property. We have matching names, appropriate names on the deeds. They do that chain of conveyance. So let me make sure I say this right. when they research the deeds and the chain of conveyance, the grantor on this deed has to match the grantee on the previous deed. The grantor on this deed being the seller, the previous deed, they were the buyer, right? So they have to link all those chains of conveyance, make sure that they properly link up. Are there any unpaid deeds of trust? In North Carolina, we're just fancy. We call our deed of trust the mortgage. So there are any outstanding mortgages on the property? If so, the seller will have to pay that as part of their settlement. We talked about getting that mortgage payoff to the day of settlement. They'll come out of the sales price before the seller can get paid. They'll have to pay that off. Are there any judgments, personal judgments? Are there liens? They're going to make sure all that gets paid off. Easements and title defects. In North Carolina, we have something called the Marketable Title Act. You don't need to know that, but the Marketable Title Act says if an attorney can trace a title back 30 years and not find any issues, they can declare the title marketable. If they find issues, they may choose to go more than 30 years. But in North Carolina, if they can go back 30 years.
Do you guys ever see divorce situations put on title work like past due child support?
Probably that would probably show up as a judgment, on the person. So yeah, anytime you sell a house, any unpaid judgments will have to be paid from the sales price before the seller gets paid. If you think about it, the seller is the last one in line to get paid from the sales price, right? And the seller gets whatever's left. That's after paying me and you and paying off all their judgments and deeds, trusts and liens and all that other stuff. And hopefully, fingers crossed for the seller, if there's something left, that's their proceeds. As we said earlier, if there's any defects on the title, it's got to be corrected by the seller prior to settlement. Other than the ones that we know about, our outstanding liens, mortgages, that kind of thing. Again, that comes from the sales price before the seller gets paid. The other thing with sellers that we as buyers agents need to make sure that we're doing to protect our buyers is making sure that no mechanics liens can be filed on the property after closing. So let's imagine a scenario. You work for the buyer, you're the buyer's agent, and you guys go under contract and the buyer has their home inspection and they find things that need to be repaired and they ask the seller to fix them. And the seller says, yeah, sure, no problem, I'll fix them. Seller fixes it 2 weeks before settlement, 14 days before settlement. We go to closing, the deed changes hands. It's now the buyer's property. Maybe we find out, maybe we don't, lo and behold, that the seller never paid that individual to do the repairs that the seller agreed to do. That individual has the right to file a mechanics lien. And they have that right to do so within 120 days after the work was done. Well, we just did the repairs 14 days before settlement, right? So the mechanic may not file the lien till day 119. Now the buyer, who by the way is the owner of the property, has a lien placed on the property for repairs that they thought the seller paid for. Who's on the hook now? Unfortunately, it's not the seller, is it? Now it's the buyer because the mechanics lien attaches to the property. So as buyer's agents, how can we protect our buyers? Well, one of the best things we can do when we're sending that repair request, that due diligence repair request, is ask to see paid in full invoices, ask to see paid in full receipts. You had painting work done? Great. Let me see that paid in full invoice. You had electrical work done? I want to see that paid in full receipt. Additionally to that, that's a step we can take to protect our buyer clients. Additionally, we'll learn one of the seller's documents that they have to sign at settlement is saying, it's an affidavit saying that that can't happen. They're swearing that everybody's been paid, that nobody can show up after the fact and file a mechanics lien. So if it does happen, the new owner has title insurance. And that's what title insurance is there. We'll talk more about that in just a second. But that's why it's there, is to protect the current owner from errors of the past. So if the seller swears they paid it and they lie, title insurance now has the right to go back after the previous homeowner. So our buyers are protected. Again, we can take that extra step. We'll talk about title insurance in just a second. Outstanding leases, we've said this a couple times. Buyers are to honor any existing listing agreements. But the buyer also has the right to know what they're buying. So they should have that opportunity to review all leases, any information about the tenants that they're getting ready to acquire as part of their due diligence. So sellers providing current information about the tenant and the lease to the buyer. We just saw that additional provisions addendum, that little provision, so that helps there as well. Earlier, a few minutes ago, we mentioned the Tenant Security Deposit Act. Buyer and seller have to figure out how they're going to transfer their funds. Today, the seller is the landlord. We go to closing. Now, tomorrow, the buyer is the owner of the landlord. And somehow we got to get that security deposit from old owner to new owner. Probably the most common, the most popular way of doing that security deposit is just to deal with it at closing. The attorney may be able to assist in transferring it from the seller's account to the buyer's account. The attorney probably is going to draft us up a new lease, right? While they're there anyway, while we have an attorney. So they're going to assist with that. I would say the least common way, and this may make your head hurt, tenant returns to seller. Seller returns to tenant. There we go. Seller returns the security deposit to the tenant. And then after closing, the new owner goes after the tenant for the security deposit. No. That just give you a little headache. That poor buyer having to track down that money from the tenant again. So usually how it's happened, the most common way how it happens is going to be at closing. Just let the attorney handle it. The parties have to agree to it, of course. But if the attorney can handle it and it's seamless, the tenant just needs to be notified that there's a new landlord where the security deposit is. We're going to talk about the earnest money deposit more in chapter 11 when we get back to that. If the real estate firm is holding the earnest money deposit, then we have a commission rule that says we cannot remove that earnest money deposit from the escrow account no earlier than 10 days prior to settlement. Now, if the closing attorney has the earnest money, it's already there, right? So we don't have to worry about dispersing it. It's already there. This is just the rule that if the listing firm, and guys, I'm here to tell you, most real estate sales firms are doing away with the trust account. Jory, does KW still have one? Aren't you with KW?
Sorry, what?
Does KW have a trust account?
I'm not sure, but we don't hold earnest money.
Okay, all right, so you don't. So most firms, and now I'm starting to hear these big name firms like Keller Williams. It used to be it was the big name ones that only have it. But a lot of firms are doing away with it. If you're in sales, residential sales, it's just too much liability. So what we're saying, the closing attorney has to have an escrow account anyway. That's how they pay everybody the proceeds after closing. So they have to have one by law anyway. So what a lot of us are saying is, we'll just let the attorney handle it. If you affiliate with a firm, if you join a firm that does have a trust account, then know that you will be part of your agent onboarding will be how they, their policies and procedures and how they want you to handle that. but I think fewer and fewer of us. Now, if you're in property management, you have to have a trust account, right? Because you got to have somewhere to put that security deposit. So if you're in property management, that's not going away. But in sales, yeah, we're like, just let the attorney handle it. It's easier that way. Again, if the real estate firm has the earnest money, there's two ways that we can disperse it for closing. Either the broker takes the check, the firm cuts a check, the broker picks the check up and delivers it to the settlement agent, to the closing attorney. Or we can deduct it from the firm's commission at closing. So let's walk through this. I'm going to get you guys paid, don't worry. So let's say you're owed, I don't know, I'm just going to make numbers up. Let's say your firm is owed $4,000 in commission. So once you have this closing, you expect to get a check for your firm for $4,000. Okay. The firm has the earnest money, and we decide to deduct the earnest money from the firm's commission. Let's just pretend that the earnest money is $1,000. What I'm telling you is, when you go back to the closing attorney after settlement to get your check, your commission check is only going to be for $3,000. So you go get your commission check for $3,000. You take that to your firm, and then your firm transfers the $1,000 earnest money from their trust account to their operating account to get the firm their full commission. You see what we did? You only brought back 3,000. So you pick your check up and you go, oh, my check isn't right. Breathe. I'll get you paid. You take a check 3,000 back to your firm. Your firm transfers $1,000 from their trust account to their operating account. Now, how much commission do they have? They have $4,000. This is the way we're starting to see this happen more and more. Fewer hands have to touch it. It doesn't have to travel up and down the road, right? Fewer people get involved. When we do math on Wednesday, we're going to see how this math is going to be handled on the closing disclosure, how that has to look in the event that it happens.
So they don't wire here?
No, you either, not yet, I guess.
Oh
So
my God.
take a check to the attorney, like you physically are responsible for driving the check to the attorney's office, or you just pick up from the attorney, drive back to your firm. Welcome to North Carolina.
That's craziness. A wire would have less hands on it and just wire it bank to bank.
Yep. I hear what you were saying. And you know, is that something the subject to change? Sure. You may have an attorney in a firm that agree to do that. We might seeing it more and more, but for most part, this is pretty much what we're doing.
I told the title company on Friday, I said, I appreciate what you did so much more. We took it for granted, but they do a whole lot compared to here.
Yep. And our attorneys pretty much do, it's to my understanding, our attorneys do what the title insurance company does. So it's not like our buyers aren't getting the, the services, it's just who's doing it. And you got to ask yourself, what state am I standing in, Okay. Again, you guys, this whole slide only pertains if the real estate firm has the earnest money. If the attorney's the escrow agent, then it's already there. We don't have to get it there. This is only if we have to get it there. Questions on this? Okay. All right. You want to take our last break? Let's come back at 4 o'clock on the dot, and we'll finish up for the day. All right. So it's like we're coming back. So I think I've said, without saying, that Wednesday is kind of a heavy math day. We'll do our closing disclosures and everything. And like I said, this is one thing that we'll discuss again, is what happens when the firm is going to deduct from their commission and how that looks on a closing disclosure. Questions on this? Jory's getting her blanket out. I know it gets chilly in here. Where, you know, the AC kicks on. So but I think if you just step outside, I think that's what we learned from Patricia in the last last break. If you just go outside, it's pretty. I know I tried to go outside yesterday between rainstorms to work on my garden some. It was so dang humid. I mean, it was literally in between clouds and it was so humid. I did get some stuff done, but not near as what I wanted to, as much as I wanted to, but that's okay. I guess I'm at an age now where I got to be careful, like not to overdo it and stuff like that. I guess, I don't know.
Is that written somewhere, Julie?
Yeah, I don't know. I'm still trying to find it, but I'm more and more reminded that I'm just not as young as what I used to be.
And let me know what book that's in when you find it.
I will. So still pre-closing. We're getting closer and closer to closing. This is getting exciting. So we're getting closer and closer. We got to deal with the earnest money, how we're going to get that to the attorney if it's not already there. That's what this slide is about. Earlier, I mentioned title insurance. Again, this is the attorney's job. So the attorney is going to arrange for title insurance. If a lender's involved, title insurance is required. If it's a cash buyer, title insurance is highly recommended. If a lender's involved, there's going to be two policies that the attorney will request. One policy is for the owner, and let's make sure we're good on this terminology. Today, they're the buyer. As soon as that deed changes hands, now they are the owner. So what title insurance does is protect the current owner from errors of the past. So when you guys see on your test next week, owner's policy, please make sure you know that we're referring to the buyer. Their policy kicks in, everybody with me, when they become the owner. That's been a source of confusion in the past. So there's two policies if a lender's involved. One covers the owner and it covers them for as long as they own the property. It starts the day they buy and it covers them for as long as they own the property. The other policy is for the lender and it protects the lender for as long as there's an outstanding loan. Once you pay that loan off, the lender no longer has an interest, do they? They've gotten all their money. They're out, they're moving on. Again, what title insurance is, let's just think about insurance. Forget about the title part of it for a second. What about insurance? Insurance is meant to cover you. It's meant to protect you when something goes wrong, right? That's the big picture of insurance. Your health insurance, car insurance, it's meant to cover you. It's meant to protect you if something goes wrong. Title insurance is no different. It's protecting the current owner and possibly the lender from anything that hit the title from the time before the buyer purchased. Remember earlier we were talking about those mechanic liens. The seller signs an affidavit that says, I promise nobody can come on and lay claim, put a lien on the property after closing. If they lie, and a mechanic does, title insurance is going to go after the former owner first. They're going to go after the seller first. And if they're dead or broke or MIA or whatever, then they will step in and cover for the current owner. We talked about the survey too. This is another really good reason, another good tool we have at our disposal to try to encourage the buyer, to do a survey. If there's an issue that comes up after settlement, after the buyer's the owner, they're the current owner of the property, and an issue comes up that would have been discovered had they had ordered a survey before they bought, title insurance isn't going to cover it. Title insurance is going to say, if you would have just gotten a survey, we would discover this and taken care of it before closing. But because you chose not to, we're not going to take care of it now. So this is one more little plug, one more little push we can try in that form I keep talking about. But I got to pull it up because it's not in our forms, because it's not technically a form we're supposed to go over in this class, but I do because it's such an important form. So we'll look at that first thing Wednesday morning. But it gives that, like that last push, that last ditch effort to have the survey done so that you can be protected under title insurance. What questions do I have on title insurance?
So is the terminology like mortgagee, mortgage or not used?
What here?
Mhm.
Yeah, probably not as much as you guys do because we don't have a mortgage. We have a deed of trust. We use grantor and beneficiary more. Grantor being the borrower, beneficiary being the lender. All used interchangeably. Yep. Okay. So the attorney, again, let's back up. We go under contract. The attorney does this very thorough search of the title. Then there's that period of time between settlement and closing that we talked about. And one of the things that the attorney will do to put their finishing touches on it is to come in here and do one more quick title search, just to make sure nothing's hit the title from the big one they did when we went under contract. So they're doing one more quick title search as part of their closing once we all leave settlement. And assuming nothing comes up, then the attorney offers their opinion to the title insurance company. Based on the attorney's opinion is when title insurance will release their coverage, their protection, but they're not going to do it without the opinion from the attorney. As we get closer and closer, at one point we need to notify the buyer of the money that they need to bring to closing. This is the math that we're going to do on Wednesday. If you're working with the seller, we need to notify the seller if they have to bring money. If they're underwater, they may have to bring money. So we need to notify the seller as well. Whatever monies buyer and seller take to settlement, they got to be readily available funds. Cashier's check, wire transfer. They can't show up with a personal check. Nobody wants to wait 5 to 10 days for that thing to clear the bank, right? So they need to show up readily available funds. Whether or not you do cashier's check or wire transfer may just depend on the attorney. Some attorneys, for example, may say anything over $25,000 is wire transfer only. So if you've never worked with this attorney before, just pick up the phone and call them. Ask them, we got a closing next week. How do you want my buyer to bring their funds? Again, as you start to get to know attorneys, you'll learn better what they do and do not like. The loan package. Golly, you guys have either been to a house in the last, bought a house in the last 10 years or helped a buyer buy a house in the last 10 years. If there's a loan involved, isn't their closing document, isn't it about that thick? Does that look right? I'm not over exaggerating by much, am I? They come in, the attorney comes in and plops down this ream of paper and says, oh, here we go, guys. I always tell my buyers to get their signing hand warmed up because you know what they're going to be doing for 45 minutes to an hour? Just signing. So they got to get their signing hand warmed up. And if the buyer's getting a loan, the loan package is the biggest part of the closing packet. The attorney handles the loan closing package with instructions from the lender. The lender tells the attorney, this is how I want my loan package handled. This is how I want this to proceed. Everything is signed at settlement. Again, you guys, tell your buyers, a lot of the forms that they're getting ready to sign in settlement, they may have previously e-signed. But the lender still likes wet signatures on many things. So now that they have them sit in front of an attorney signing a loan package, they may resend some of that for a wet signature. So let your buyers know it may seem like there might be duplicates, but that's okay, all part of the process. So we come in, a buyer comes in, signs all their loan documents. The attorney then sends the loan package back to the lender for their final approval. The lender's going to make sure that everything's signed and dated, all the I's are dotted and the T's are crossed. And upon satisfactory completion of the loan package, that's when the lender releases their funds. So one of the very last things to happen is the lender will send their funds into the attorney, but they're not going to do it. And guys, the voice of experience speaking here, you may want to consider telling your buyers not to get too far away from the closing attorney's office. Because if that loan package goes back to the lender and the lender says you forgot a signature or you forgot to initial or whatever, they're not going to release the funds until they have it complete. I've never had it happen to me before, but I have other agents say that their buyers, somehow a signature got missed, for example, and their buyers have had to go back. So remember we talked about, we try really hard for settlement and closing to all happen on the same day, but sometimes things happen. So you may, just a suggestion, but you may want to talk to your buyers about not getting too far away from the closing attorney's office in the event that they need to come back. The lender is not going to release their funds until they are satisfied with their loan packet.
So, are you serious?
I don't have to make stuff up, Patricia.
In Texas, we have a form that's a waiver that the title companies can use in case a doc is missed.
Nope.
They
Now, if
don't
I'm
have to come back.
working with the sellers, I may have a limited power of attorney. So if the sellers miss something or need to sign something, but usually the lender, they want the buyer.
Either party.
Yep, they want the buyer. Yep. Again, you're never going to find that in a textbook or a manual. There's just, may just want to let your buyers know, look, there's a coffee shop right there. Why don't you go hang out for an hour and a half, 2 hours, and then that way they'll be close. What the heck? Take them out to lunch or something, go out and celebrate. But you just may want to suggest that they consider staying close. So let's talk about our responsibility with the closing disclosure. That's going to be our main topic on Wednesday. But we have a duty to review the closing disclosure for accuracy. Now, we're going to get into more detail about what it is that we need to review, the numbers that we need to verify, that kind of thing. But our role in all this with the attorney is verifying that those numbers for our buyers and sellers, their closing disclosure are accurate. That's why we go through the exercise that we do in this class. All right, a couple different types of closing methods. First one, I'm guessing this is what you do in Texas and possibly even Virginia. Something called an escrow closing method. Is this what you guys do? Escrow closing? Lindsay, no? You may still be a settlement meeting. We'll get to you next then. We don't do this in North Carolina. This is what I do know. We don't do this in North Carolina. So in this method, in these states, closing is performed by an escrow agent. The parties don't attend. They just send their stuff in. These states may have something called a relation back doctrine. And what this says is that the deed is considered delivered once the seller has given it to the escrow agent. Relation back, it dates back to when it was delivered to the escrow agent. So everybody just sends their stuff in, the escrow agent does their thing, and boom, closing happens. Other states, I don't know particularly, nope, not in Texas, okay. I don't know what other states do this, escrow closing method, that's what I know. What do we do in North Carolina? In North Carolina, we do something called a settlement meeting method. in which case our residential closings are handled by an attorney. We are an attorney close state. So what does this mean? You more than likely will have a buyer moving in from another state. North Carolina is one of few settlement meeting method states left. So your buyer's coming in from another state. At some point, they're going to look at you and say, do I have to hire an attorney? And our answer is, if you're buying a home that's located in the state of North Carolina, yes, you have to hire an attorney. We are a settlement meeting method state. As we said, that attorney represents the buyer and their lender, if they have a lender. Sellers are welcome to get their own representation. In a settlement meeting method state, you may have a case for non-lawyers. You may have a role for non-lawyers in the closing. Think of your attorneys paralegals, for example. Attorneys paralegals have the ability to assist the attorney, various things that they can and cannot do. Let's first talk about what they can do. Non-lawyers can present and identify documents. The attorney drafts up the documents, but the paralegal or the non-lawyer can present the documents. They can point, tell people where to sign and date here. Y'all remember used to have little tabs on all the forms, anything you ever sign, it had a little tab that said sign here and initial here and date here. That's pretty much what our non-lawyers doing, showing the parties where to sign. They can make sure that the documents have been properly executed. Keep in mind that it's the attorney that's drafting them. What they're doing is making sure that they've been properly executed. And what's that other fancy word, fancy definition for executed? That it has been signed. So they're making sure that the documents have been properly executed. They can receive and disperse closing funds. So they can bring money in, they can pay money out, they can pay the agents on the seller proceeds. The non-lawyer cannot perform any lawful practice. Remember, that's the job of the attorney. State closing guide. We'll have to check that out in just a second. What is that, Lindsay?
Yeah, so it was saying that Texas and Virginia are they're mixed closing states. So I'm curious because I hadn't heard that term before. But I mean, we do have, where title companies can handle closings. It doesn't have to be an attorney, but so I guess we can do both.
Gotcha. Thank you. Thank you.
Yeah, sure. Yeah.
Real estate agents could also have a role in the closing, but I really don't want to go down that rabbit hole. So instead, I want to direct your attention to page 471. And I'll let you guys read that section, closing coordinated by real estate broker. You guys see that? I'll let you read that on your own. What I really want to point out to you is the big bold. Brokers are strongly discouraged from attempting to act as a settlement agent. A broker acting as a settlement agent will be held strictly accountable by the North Carolina Real Estate Commission for assuring that all aspects of the closing are handled properly and that the broker uses an attorney to perform all closing functions that require a law license. I say all this to say to you guys, let the attorney do it. We don't need to get involved. Let them do their job. I know we think, well, I'm here to help. No, stay in your lane. Let the attorney handle the closing. We are just brokers. So we saw a list here of things that non-lawyers can do. Let's talk about what non-lawyers, paralegals cannot do. What can't they do? They cannot offer their opinion of title. That's something that the attorney and only the attorney can offer to the title insurance company. They can't explain the legalities of the title. Again, that's the attorney's job. They can't, nor can we advise parties on how to take title. So if you're working with buyers that are unmarried, we need to decide if they want joint tenancy or tenancy in common, right? That's not up for me to help them decide, y'all. I'm not going to whip out my pre-licensing book and say, oh, well, this is what it says about joint tenancy. This is what it says about tenancy in common. If you're working with unmarried buyers, you need to suggest that they set up a conference call with the attorney so the attorney can advise them how to take title. The attorney can recommend how they should take title. And then non-lawyers cannot draft legally binding documents. Remember, that's the job of the attorney. So let the attorney do their job. All right, settlement meeting, we're at the attorney's office. So who's there? Buyers almost always have to attend settlement. There may be, the lender may allow for an exception to do a mail away closing. I'm almost going to have to say that's got to be a pretty rare exception. I did a mail away closing once. Both buyers, husband and wife, when I met them, were currently actively deployed. She was in Italy and he was in Japan. So we went under contract. I was taking videos of homes because we're on 3 different time zones now, right? I'm in North Carolina, she's in Italy, and he's in Japan. So I'm taking videos showing them property that way. They find one, we go under contract. She comes stateside. So she did get to see the house before they closed in person. That made me feel a lot better. She comes stateside. She's stationed in Maryland now. The plan is she's coming down for closing and she has power of attorney for him. So she can come down and sign for both of them. Guess what happened the day before settlement? Her sergeant said, you ain't leaving this base. Day before. So we all took a big deep breath. What do? The lender allowed us to do a mail away closing. Again, I share that story because to me, that's more the exception than the norm. And it was really out of anybody's control. Most of the time, the lender wants the buyers there, but they may be willing to make an exception. Buyers agents, we need to go to closing with our buyers. Come on, guys. We've been with them since day one. Why are we going to bail with them on the last day, right? So go with them to closing. It helps if there's any questions about the contract comes up, you have that information. Take your tablet or something in case you need to pull up your documentation. It also just helps to have a familiar face. Have you guys bought a house? I mean, it can be a nerve-wracking process, especially if you're not familiar with it. I will never forget when I bought my little condo back in 2006. I wasn't licensed yet. I was working in real estate, but I didn't have a license yet. And I pulled up to the attorney's office and got out the car, and I swear my knees turned to jello. And I'm like, what am I doing? I can't buy this condo. And I started having doubt, fear, and everything else. And about the time I was getting ready to get back in my car, here comes my agent. Hey, Julie, you ready to do this? No, but she taught me up. She got me up there. It was nice to have that support. So guys, buyers agents, go with your buyers to closing, be there with them. Again, the important thing is if questions or anything comes up. Sellers may or may not attend settlement. Sellers can either attend and sign and turn in their keys, or they can sign all their paperwork ahead of time with a notary, and then the agent can deliver their documents to the attorney's office. It's been my experience, some sellers are so over it, they have no interest in attending the attorney's office. Other sellers want to see this thing through to the very end. So leave that up to your sellers, how and when. If your seller attends, you as the listing agent need to be with them. Again, offering that support, available to answer any questions. Obviously, the attorney and or paralegal will be there, helping people know what to sign, where, pointing, sign here, sign here. If you're using a local lender, the local lender may come to settlement as well. Again, just to offer support, be there if you have any questions about the loan. As far as location of settlement, doesn't matter. Wherever the buyer decides. Typically, settlement's going to happen at the closing attorney's office. I have had closings in the conference room at the real estate firm. The attorney comes to the real estate firm. There was an attorney in Greensboro many years ago. She practiced out of her home. So settlement happened at her dining room table. First time, that was a little awkward, I'm not going to lie. But when she got used to it, it got a little easier. But my point here is that where settlement takes place really doesn't matter. The contract says it's up to the buyer.
So Julie, you guys don't do notaries?
The seller has to sign in front of the notary, and usually that's why the buyer's sitting in front of the attorney, right? So then they go and have their guys notarize it usually afterwards. But yes, both parties have stuff that needs to be notarized. Attorney's got you covered though. Yep. Okay. Again, settlement, the attorneys making sure everything's signed. Settlement is when buyers and sellers come in. Usually when buyers and sellers come into the attorney's office for settlement, the attorney will provide non-signed documents. They may send or make arrangements for copies of signed documents afterwards. The North Carolina Good Funds Settlement Act is the act that says funds will not be dispersed to anyone at settlement meeting. So when you go with your buyers and sellers and sit there and have them sign all their documents, you're not going to get paid at that time. You get paid when it closes. You get paid when that deed records. My favorite expression in this industry, you'll get an email from the paralegal that says, "We are on record." That's all it has to say. That's all I need to know. Loosely translated, go back and get your check. Give your buyer their keys, right? It's not a done deal until it's on record. So when they notify you that we're on record, they have submitted it to the Register of Deeds, and the Register of Deeds has confirmed a receipt. Then they email you that we're on record, go get your check.
So attorneys don't wire the agent's accounts?
No,
Oh my God.
no. She still doesn't like that, does she? We got to go back and get our check. And if they have earnest money, they're going to deduct it from my commission. That's what you're just talking about earlier. Yep. Yep. Don't go far. Again, we want it all to happen on the same day, right? You may have it mailed. I'll let you lay that up to your firm's policy. Some firms will say have it mailed. Some agents say, I don't want to wait that long. I'm going to go back and get my check so I can get paid like tomorrow. So good fund settlement. And guys, this isn't just saying you and I aren't going to get paid until it closes. This is everybody. This is the attorney. This is the lender. This is the home inspector. This is everybody that's submitted an invoice and is waiting for this thing to close to get paid. It's not going to happen at settlement. It's going to happen at closing. Last little piece in this section. Again, we're still, once we leave the attorney's office, there's this period of time between settlement and closing, that deed being recorded. So the attorney's going to do their last quick final title update. They have to record the payoff of all the seller's outstanding liens before they can record the buyer's new deed. So they have to have it on record that everything's been paid off. Then they record the new deed. Everything's got to have that nice date and time stamp. Again, once that deed has been put on record, then all the funds can be dispersed. That's when everybody gets paid, when it's a done deal. The sellers may have to report the sale of their property to the IRS. It's a form 1099-S. You don't need to know that, but it's an IRS form. Usually the attorney will handle submitting that form on behalf of the sellers, just in case somebody forgets and it doesn't get there of course, by accident. So the attorney can send that down. Again, if you're working with a seller, just tell them they may want to talk to their accountant. What kind of tax benefits, what kind of breaks are they going to get for selling a house this year? I don't know. I'm not an accountant. So advise them to talk to their accountant. Same thing with buyers. If you buy a house, you may be eligible for tax benefits. What are those? I don't know. I'm not an accountant. We've got to stay in our lane. Unless you guys are an accountant or current on the current tax laws, we can't be given tax advice. I see Lindsay shaking her head. I'm right there with you. I dodged that bullet. I just married an accountant, so that way I can let him handle everything. I'm like, there you go. Here's my receipts for the year. Get me some money. That's how I do my taxes. Questions? Okay. Next little section in chapter 14. Again, we're getting closer and closer. Still got a few minutes though. We need to talk about RESPA. We need to talk about TRID. We're going to get a little bit more in depth with these, and we will define both of these in just a second as well. So continuing on, moving right along. Now we are, fast forward, we're on page 474. We're going to talk about RESPA and TRID in this section. So we're going to discuss and define RESPA and explain TRID. So first and foremost, what is TRID? What is RESPA? You know, we said earlier that in real estate, we have our own jargon, our own language. And if we can make an acronym out of it, we're going to. And TRID is the acronymous of all acronyms. TRID is the acronym within acronyms. The T in TRID stands for TILA. TILA is an acronym for the Truth in Lending Act. The R in TRID stands for RESPA. RESPA is an acronym for the Real Estate Settlement Procedures Act. TRID is the integration of TILA and RESPA. Now, before we talk further about these, let's please all understand, TILA has always been around. RESPA has always been around. TILA and RESPA are nothing new. TRID combined them. TRID put them together, integrated disclosure. A lot of the complaints that consumers had when buying a house and obtaining a mortgage loan was duplicate content. And the forms look very similar. TILA had their forms, RESPA had their forms, and they look very similar. And the consumer was getting confused. They were like, why am I signing the same thing twice? So one thing they did as a result of the housing market crash back in 2008, 2009, 2010, they combined the two and they gave us TRID. TILA informs the consumer of the cost to obtain the loan. When you see TILA, see the word lending. TILA informs the consumer of the cost to obtain the loan. RESPA informs the consumer of the cost to close. When you see RESPA, see settlement. You know, when we're at settlement, we are one step away from closing. So TILA is about the cost to obtain the loan. RESPA is the cost to close. And again, the two together. We will talk more about TRID. We'll see this again on Wednesday. But right now, let's just focus a little bit more on RESPA. Let's just hone in and talk a little bit more about RESPA. TRID, RESPA's whole purpose is to protect the consumers when they're dealing with mortgage lenders, any federally related mortgage loan. RESPA and TRID are only around when a lender is involved. If it's a cash buyer, does TRID apply? No, because there's not a lender involved. If it's a cash buyer, the rule is, well, there are no rules. If it's a cash buyer, we don't have as many regulations, guidelines that we have to follow. RESPA was administered by the Consumer Financial Protection Bureau. The CFPB was who said, we need to consolidate some of these forms. We need to make it easier for the consumer to understand. We need to disclose information. The CFPB was one of the results of the housing market crash. I don't know if Patricia and Lindsay, if you guys have been in the industry that long, if you were around before or during the housing market crash. It was tough times during the housing market crash. You guys know. Congratulations to you for still being here, myself included. You know, times was tough if you were in real estate during that time. There are a cajillion theories out there about what caused the housing market crash. We're not going to get into all those theories, but I will say one of the strongest theories was fraudulent lending practices. And some will say that it was fraudulent lending practices that was a big part that caused the housing market crash. Prior to the housing market crash, it was really, really easy to get a home loan. Too easy. It's kind of like Oprah was giving those things out, right? Like, you get a loan, everybody gets a loan. It was kind of like that. And they came in and said, okay, we've got to do something. That's when the CFPB was formed, and that's when they created TRID. They integrated TILA and RESPA. So RESPA applies again to federally related mortgage loans for properties that are 1 to 4 family, residence lots, or mobile homes. Anything 5 or more doesn't fall under TRID, doesn't fall under RESPA. It's only 1 to 4. It's to protect consumers when dealing with lenders whose deposits are insured by the federal government. And you may also hear RESPA referred to as Regulation X. TILA, FYI, is Regulation Z. RESPA is Regulation X. So this is when RESPA is around. When is RESPA not around? Well, if it's a cash buyer, as we just said, any kind of apartment complex that's more than 4 units, 5 or more, RESPA is not going to be around. RESPA doesn't apply. Commercial properties, Lindsay doesn't have to deal with RESPA. Business, if you're purchasing for your business purposes, and agricultural. So what are we looking at? As we just said, residential, 1 to 4 family, federally related mortgage loans. So on page 475, we're going to start. We won't get through this today, so we'll pick back up here on Wednesday, wherever we leave off. But on 475, you guys see those 7 things that RESPA does to protect the consumer. So there's a nice little summary on page 475. We're going to go through this. You get more detail on this information starting on page 476. So again, 475 is just the summary, the recap, if you will. And then we're going to get into some more information, detailed information, starting on page 476. Please understand, this is not everything that RESPA does to protect the consumer, but these are just things in particular that we're going to discuss in this class. And the first thing that RESPA does to protect the consumers, they offer a yield spread premium, a borrower credit, I should say, for that yield spread premium. So let's talk first off about what this yield spread premium is. Any premium that's paid for making the loan, maybe you have a mortgage broker, for example. The mortgage broker job is to connect the borrower to the lender. They brokerage that transaction. So maybe that mortgage broker has a premium paid for making a loan with an above market interest rate. Anything above market is going to increase the lender's yield. The higher the yield, the more sellable the loan is on the secondary market. So lenders want loans with high yields, so they have a better product to sell to the secondary mortgage market. It's like placement on the shelves at the store, right? They want it in the good place, in the eye level where everybody can see it. They don't want it way up top. It's got to have a good yield. And it used to be that borrowers would pay for this yield spread premium and have no idea. It wasn't disclosed to them. They didn't know. They were just being told to sign here. RESPA says, stop it. If you're going to make the borrower pay for that yield spread premium, you have to disclose it. And at closing, you got to give them a credit for that. The borrower shouldn't be the one paying to make the loan more sellable, to make the lender's yield higher. So RESPA came in and said, if the premium is paid, it needs to be disclosed and they need to have a credit back. Everything's going to be, as we see when we do this closing disclosure on Wednesday, everything's going to be broken down, detailed. You're not just going to have a number. They're going to tell you how they get to that number. We're going to explain to the consumer where these numbers come from now. Instead of saying, oh, just sign here and pay this. We're now explaining, we're helping to educate the consumer. Y'all think about it. In many cases, these buyers are originating 30-year loans. That's a heck of a commitment, isn't it? I mean, that's a 30-year commitment. Have any of you been married 30 years? I know I haven't. That's a long, Vivian has, good for you. That's a long commitment, isn't it? That's a long time. So lenders are saying, look, if you're going to make this 30-year commitment, don't you have a right to know about each other? Don't you have a right to have all the information? So borrower credit for yield spread premium, if it's paid, they're going to be credited. Another thing that RESPA does to protect the consumers is about loan servicing. What we mean by loan servicing is whether or not the loan can be sold. So it's not uncommon to originate a loan and then they sell it on the secondary market, sell it to another lender. The only reason they're doing that is to replenish their funds so they can originate new loans. Lenders don't have some kind of endless money supply, right? They don't have a money tree out back that they can just go pluck $100,000 bill from and say, here you go, here's your loan. So they have to get their money from somewhere as well. If your loan can be serviced, RESPA says there's two things that need to happen. One, you need to be notified prior to originating the loan if your loan can be sold, transferred, or assigned. Can it be serviced? Not all lenders sell their loans. Some do keep them in-house. And then the second thing that RESPA requires is that the borrower be notified when the loan is serviced. I think I told you guys earlier that my loan was sold. I received 2 pieces of mail, one from my old lender telling me that they've sold my loan, one from the new lender telling me that they've purchased my loan. And that's a RESPA thing. RESPA requires both at the time that it can be transferred, the time that it can be serviced. Another thing that RESPA does to protect the consumers, they put restriction on escrow accounts. So you originate a new mortgage loan today. You originate the loan, buy a house and originate the loan today. The lender's going to create an escrow account on your behalf. And once you start making your mortgage payments, 1/12 of your annual taxes and 1/12 of your annual homeowner's insurance, that 1/12 is going to be part of your escrow payment, your mortgage payment, excuse me. So each month you make that mortgage payment, that money goes into your escrow account. And at the end of the year, the lender has that money in your account to pay your bills on your behalf. So they pay your homeowner's insurance for you. They pay your real property taxes for you. Isn't that nice? All you got to do is pay 1/12 in. So they first off are restricted on how much they can collect from you each month. The first restriction is that they can only collect 1/12 of this year's property taxes, and they can only collect 1/12 of this year homeowner's insurance. Is there a good chance those could go up next year? Yeah, they like to do that, don't they? Next year they can collect more, but it can still only be a 12th. A 12th of the current years is all they can collect. The second piece of the escrow account restrictions is when they're originating the escrow account for the borrower at closing. And there's restrictions on how much they can collect at closing to originate that account. They need to originate the account. They want a little bit of cushion, because if those bills go up next year, they still want to have the money to pay those on your behalf. So RESPA allows the lender to collect a cushion at closing. We will see this on Wednesday when we do our closing disclosure. But the restriction is they can't collect more than 2 months at closing. So they're limited to how much. The thing about the escrow account, you guys, if you go to pay your loan off and there's any money left in the escrow account, you're going to get that money back. So you put some in at closing to originate the account, start the account, and you pay into it throughout the time that every time you make your mortgage payment. But when you sell your house or when you pay that loan off, if there's anything left, you either get a credit or you give you that money back. So in other words, that's not their money. It's them managing your money, and they're paying those bills on your behalf. We actually just paid the condo off the end of last year. That's what I did on New Year's Eve. I went and paid my condo off. That was very exciting. And middle of January, I got a check in the mail from the lender. I got a check from the lender. I was like, well, this is nice. What's that about? You know what it was? It was the money that I had left in my escrow account, the money that they didn't use. So they actually wrote me a check and gave it back. Nice. You know what you could use after you pay off a condo? A check. Very helpful. Another thing that RESPA does to protect the consumer, and this is the one that hit us. This is the one that hit us personally. RESPA says, all right, real estate agents, no more kickbacks or referral fees. RESPA says settlement service providers cannot give or receive any kind of kickback or referral fee for suggesting that your clients use this settlement service provider. I can't give or receive. Real estate agents are settlement service providers. The lender, the attorney, the home inspector, the appraiser, everybody involved is considered a settlement service provider. And what RESPA says is we cannot give or receive anything of value. I can recommend that my buyer use this home inspector. I cannot receive a thank you from the home inspector for recommending my buyer to him. Does that make sense? They cannot give me $1. They cannot give me a donut. All they can do is say, thank you, Julie, for recommending your buyer. I hope you will recommend your future buyers to me. It used to be these gifts were nice. Maybe the home inspector gave you a $25 gift card to Target. All you had to do was send them a buyer. Maybe the lender would have a big pool. And every time you sent a buyer to the lender, they'd put your name in the hat. And at the end of the year, they're going to do a drawing for like an all expenses paid cruise. Let's be honest. If the lender's offering that, why am I sending my buyer to this lender? Is it because they're the best and they'll do the best work for my buyer? Maybe they will, maybe they won't. I'm doing it because I want my name in the hat to get a chance to win a cruise at the end of the year. Is that what's the best interest for my buyer? No. And that's why RESPA says this have to stop. This is also when we started saying, here's a list of 2 or 3 lenders. I suggest you go to Google, do your research, and figure out which one you want to use. We're always offering those suggestions, and I can't give or receive. Like I said, some of those gifts were really nice. No more. Yes, ma'am.
Can those vendors co-brand with you?
Absolutely. But
Okay.
I'm not getting anything. That's a great question. So can the lender and I be on a flyer together promoting a property? Absolutely. The other thing, the home inspector, remember we just said I can't get $1 or a donut, right? Anything. The home inspector can come into the office with a box of donuts and a stack of business cards and say, hey guys, here you go. I'm going to put these in the kitchen. You guys help yourselves. Now, why is he doing that? Because he wants me to pick up a donut and a business card and possibly use him, right? He can do that. What he can't do is come in the door and say, here's a box of donuts. They are for you, you, and you, because you gave me buyers last month. So what they're going to have to do for one in the office, they got to do for everybody. They got to make it available to everybody. They can't just select those that gave them business. Does that make sense? Post-COVID, a lot of you don't know real estate without COVID. Half of you, I guess, don't. I'm telling you, vendors are starting to come back. They're starting to bring lunch, and they're starting to bring donuts again, and they're starting to come back into the office. And that's okay as long as it's a whole office thing and they're not coming in and specializing who, and who. One thing, and I think this is important, really important that we understand, RESPA says we can still do agent to agent referral fees. So if you have an agent, if you have a buyer that wants to buy down at the coast and you don't have the resources or the means to help them buy at the coast, you can refer them to an agent at the coast. And when it closes, you can collect a referral fee. RESPA still allows agent to agent. I'm glad they didn't take that away from us. But what you can't do is recommend services and get something for it, give or receive. The other thing about this that RESPA says is disclosure of affiliated business arrangements. So if you're in business with somebody and you stand to make, for example, we're starting to see this idea of one-stop shopping come up. So under one roof, you can get an agent, a lender, and an attorney. We're all right there, one-stop shopping. Can I make my buyer use that attorney or that lender that's under the same roof as me? Absolutely not. I can suggest them and I can recommend them, right? I can have them as one of my 2 or 3, but I can't force them. And if my firm makes anything because of that business arrangement, I have to disclose it. So if the 3 are in part, if you use these guys, we're going to get a 1%. You see what I'm saying? We have to disclose what that business arrangement is. I used to work with a woman, and she's a real estate agent, and her husband is a home inspector. I would consider that an affiliated business arrangement. Now she's working with buyers. She can't make her buyers use her husband to inspect properties, can she? She can recommend her husband. Do you think she should disclose this is her husband? Because she stands to benefit from that, right? So she can say, my husband's a home inspector, here's his company. And if they say, no, I don't like that. Okay, then what inspector would you like? You guys with me? Always give them choices, never, ever say. All right, so we're gonna pick back up here. We still got some more things to talk about with RESPA to protect the consumers. Don't go anywhere just yet. I'm not done. I do want to just point out, do you guys have the ability to print? Does everybody have the ability to print? Okay, Vivian, Jory, do you? Okay. What we're gonna do on Wednesday, if I can find it. There we go. If you guys look in this section 6B closing problem, if you guys will, it's in Learn Test Pass, section 6B closing problem. And if you will look here in the blank closing disclosure, this is, let's call this the worksheet that we're going to use on Wednesday. If you guys can print a few of these out so you can work them with me between now and Wednesday, that would be great. For our test next week, you're allowed to have a blank one of these for your exam. So we'll have you guys print one on, but go ahead before tomorrow or no, whenever we meet again. Wednesday, I think I just said. And if you guys will print that out, and it's 2 pages. So if you want to do front and back, or if you know, whatever you want to do. But this is where we're heading. This is where we'll spend most of the day on Wednesday.
So Julie, the
Yes, ma'am.
agents actually determine closing costs?
No, the paralegal, I should say the attorney and the lender do. We're reviewing it for accuracy. We're making sure that the numbers are right. So the attorney prepares these things, but we owe it to our clients to make sure that their bottom numbers are right. So that's what, in this class, we're actually going to prepare one, because what better way to understand it than sit down and start with it from scratch. Yep. So that's a great question. I know a lot of times I forget to mention that. I think I freak some new agents out. You mean I have to? No. But we do have that duty to review it for accuracy. Other questions? Day 1, we're 1/4 of the way there. How about that? Everybody doing good? Everybody hanging in there with me? I'll have our YouTube channel. I'll try to send that to you guys tonight so you can have the recording from today. Again, I think it's more important that you guys get it before the weekend, because we're going to do the math on Wednesday. So I think you'll definitely want the recording to be able to go back at your own pace. So bring your blank closing disclosure or ERS, however many you want. Bring your calculator. We got, I don't know, maybe another hour and a half or something of other stuff to talk about. And then we're going to get in the math. So bring your math mind on Wednesday too. Fair enough? Questions, comments, concerns?
I appreciate that you walk around.
I cannot sit still. This was hard for me. If we were in person, I'd be all over the room.
Yeah, most instructors sit down though.
I can't do it. I don't even think my voice projects right. I got a sit stand table. Y'all check out my toy that I got with Zoom. So I hit a button and my desk will lower. So now I'm in a seated position. Sit stand table. I love it. It's programmed to my heights and everything. That's my new toy.
You got a Varidesk?
Huh?
You got a Varidesk?
No, it's just a table.
Oh, okay.
Yeah. So I don't know what the brand is. Amazon. You find anything there, can't you?
Yes, you can.
It's amazing.
No matter
All right.
what it is, it's out there.
That's right. Whether you knew you needed it or not, right? Well, y'all have a wonderful evening. I hope you guys have a good day tomorrow. I'll get you that recording, but we'll pick back up here where we left off on Wednesday and keep going. Please don't hesitate to reach out to me if you guys have any questions. That's why I'm here. So make sure you utilize me as a tool and a resource as well. Okay. All right. Y'all have a good evening, and we'll see you guys on Wednesday.